குட் மார்னிங் ஸ்ரீராம். அதான் அந்த ரெண்டு ரெண்டு மூணு பெண்டிங் இது முடிச்சிடலான்னு ஸ்ரீராம்.
But ಇಲ್ಲ ಆಗಿಲ್ಲ ಓಪನ್ ನಾಗರಾಜ್ ಓಪನ್ ಆಗಿಲ್ಲ ಏನ್ ಮಾಡ್ತೀವಿ ಅದೇನ್ ಮಾಡ್ತೀವಿ ಓಪನ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಕೊಡಿ ಮಂಡೆ
Seek for adjournment. How can you say urgency? You must not ask for date once you seek for adjournment. That the court will do. We'll list the matter next week. Next week it will come. This matter. Yes, 42.
My lords, I'm appearing in 42 on behalf of the petitioner. I just have one small request, my lords, in this matter.
Yes.
My lords, may just see, the cause list itself. It says below 42, WA1145-2015 is pending before the Honorable DB. I was trying to mention this matter last week also at the end of the board. The matter didn't come up. My lords, if this matter was supposed to be heard after the decision of the full bench, that decision is out. Now, registry says that because the decision of the full bench has directed it back to the division bench, so we'll wait for the division bench order. Now, that is not the correct position as per the order in this very writ petition. In this very writ petition, Honorable Single Judge on the last occasion had said that after the full decision in full bench, which by the way is in my favor, this matter will be taken up. So the only indulgence I want is if this matter can be taken up in the orders category or preliminary hearing so that the matter can actually be taken up and disposed of. It's a small issue, my lords.
Use the mic. Use the mic. Mic. This mic has been muted deliberately.
My lords, I'm unable to hear, but if my lords can just have the application at Annexure 2 itself or the order dated 18/7/2019.
Yeah. No, let's do one thing. Let it come up. I will accommodate. But when it reaches, you both of you make your submissions. What is it that is going to be argued? Then I'll fix a date. So let it come up. Let it be in the list. We'll see.
Much obliged.
Yes. What's the matter? Week after next. Full this. Third. Fourth. Fourth. Fifth.
Case number 6, 44 to 49. Case number 7, 50 to 59.
Yes. It's the matter on 12th. A request. It's the matter on 12th. A request made on behalf of the respondent. Yes.
Fresh letter, serial number, RFL, GA. Yeah, doctor. Okay.
Income tax. Lord Council Sanmati accepts notice for respondents 1 to 4. Let them get instruction. We'll consider your request next week. Next week, let them get a preliminary instruction. Next week, we'll consider it. Next Wednesday, 28th, or else on the Wednesday following that. 28th. Soft copies.
One thing, the 19th, when they have informed me the jobs for which I have to pay. And on 26th, they have passed ex parte order. No date has been given. No response. And 2 stream of proceedings are going on by that simultaneously for that default measure. And one is not yet completed. I have received notice after passing the order from the other order. And that is showing penalty proceeding pending matter. This is the high case, this classic case of my lord. And faceless penalty scheme. And that specifies that they have to give me specific date and time, file the response. And in the order itself, EO is admitting that I have not given any time. And there's clear case of, classic case of not following the principle of natural justice. And which is in the scheme of the act itself, 74, my lord. And this court division bench has held that you have to give the proper opportunity. If you want to levy any penalty under section 74, you have to give proper opportunity. And you have to inform the charge. They, after seeking 3 times, they have informed the made the charge for which I have to be levied the penalty, show cause. And that too by 19th May, they have informed me the charge. And 26th, by expert order, they have found 1,58 lakh. And my reply was ready. My reply was ready on 27th. I have filed with previous complete reply along with all documentary evidence. This is clear case to set aside before the on the face of it. I can show you are not.
The matter in preliminary hearing list on 28th. You have served copies. Wherever you are seeking ex parte stay, it's better. I request the council to keep an extra copy, because if there is, sometimes they'll be in a position to concede for an ex parte order. Otherwise, normally I adjourn it. It's better to give them so that in prima facie, if they are satisfied. Yes.
My lord, in this case, there is an attempt, department wants to open the
item number 2.
ऑनलाइन डिस्प्ले बोर्ड खोल
Online display board.
Yes.
Before I go to series of that, I will see of. Oh my God.
No, then we need not enter into merits. Just find out. Now, if he is asked for an adjournment, so be it. Give once more when here and that's it. Why keep this matter?
I am not asking for owners. I just restricted this. I was always. You are but cannot pass on. I'm only seeking distribution back to the because I provide this. I am very ready. I have never been under the tax tax problems. I have been concerned about moderate tax. I'm certain I will satisfy that I have there's nothing to hide.
You take instructions, I'll stay it. We'll have it in the preliminary hearing list. We find out. Small matters, let us see.
Each time I not practically state the data.
That's why I say we must give an extra copy. The counsel for the petitioner would submit that in response to notice under 148 capital A small b, the petitioner had sought for extension of time to file his reply, and the 148 capital A D order was passed without considering such adjournment application. Mr. Subject to further consideration, there would be stay of annexure A1 to A3 till the next date. List the matter in the preliminary hearing list on date could not 28th. 28th is full. Next note full agad beda.
Yeah.
12th. 12th. Vijay. Calendar you can it on. Hello, cancel. We list the matter. Learned VGA. Sri Hemkumar accepts notice for respondents 1, 2, 3. List the matter week of the next date. Huh? Let us 5th July. Let us. Yes. Just use the mic. Just see if the mic is on.
In the year 2018, the petitioner has purchased a vehicle from Proceedings showroom, my lord. Pursuant to which he has filed the tax and he has got received the registration certificate as well as the pre-register extract, the RTO. Pursuant to which, in the year 2021, the Commissioner of Transport and Road Safety issues an order for purpose of verification of non-payment of tax at the time of registration of his vehicle. Thereafter, the petitioner receives a notice from the respondent calling the petitioner to produce proof of having paid the tax for the said vehicle. Pursuant to which, my lord, this at the time of purchasing the vehicle, one Mr. Ajay Jain represents to the petitioner that he is the agent of the RTO, and through Ajay Jain, the petitioner has paid the tax to the RTO. Whereas when the notice was received by the petitioner contacts Mr. Ajay Jain, whereupon he finds that Mr. Ajay Jain has been arrested at the Rajasthan police station with respect to crime number 95 part 2022, wherein it alleged that Mr. Ajay Jain has cheated and duped various vehicle owners with respect to payment of tax. My lord, if you choose annexure B, my lord, which is the pre-register extract.
But how is Kumar's client responsible for this?
My lord, he has disturbance was that is
correct, but how is Kumar's client responsible for this? How is the government responsible for this? Except that the government must be tighten the office there. Page? Page 10. Annexure A. No, so which is the document here? Registration. Tax up to RTO. RTO. Taking note of interim order passed in identical circumstances in WP 12135 of 2022. Respondents are directed not to take any precipitative/coercive steps against the petitioner in the next date of hearing. The notice ಹೇಳಿದ್ನ where the EGA Kumar accepts notice for the respondent. Now, what is the stage of the inquiry? The state to file report of inquiry. Report of inquiry stated to have been instituted. But you must also fix in the whatever liability, personal liability at each stage. What happens sometimes that some of them get away. Whoever has done it, it must go to the logical end. Yes. It's scan again. This is against the revisional order. In the appeal, you were granted relief.
Yes, sir. Each question of law that arises is going to this. Whether the power under 108 power of review has been exercised in the jurisdiction of revision of section 108 of the Act. The question arises whether the revisional authority exercising powers under section 108 can review an appellate order under section 107. In this case, the appellate order is in my favor. The respondent in that case, that is the assessment officer, respondent number 3 in this case. If he is aggrieved by it, the remedy lies only against further appeal and not by way of exercising the jurisdiction under 108. Because appellate authority's order can only, the contention in this exception my lords is that appellate authority's order can only be reviewed by a further appellate authority and not by the authority under section 108, the revisional order.
Just take me to 108.
108. Yes, yeah.
Yes.
May I read below, subsection 1. Subject to the provisions of section 121 and any rules made thereunder, the revisional authority may, on his own motion or upon information received by him or on request by the Commissioner of State Tax or Commissioner of Union Tax, call for and examine the record of any proceedings. And if he considers that any decision or order passed under this Act or under the State Goods and Service Tax Act or the Union Territory Goods and Service Tax Act by any officer subordinate to him is erroneous insofar as it is prejudicial to the interest of revenue and is illegal or improper or has not taken into account certain material facts, whether available at the time of issuance of the said order or not, or in consequence of any observation by the CAG, he may, if necessary, stay the operation of such decision or order for such period as he deems fit. And after giving a person concerned any opportunity of being heard and after making such further inquiry as he may pass such order as he thinks just and proper, and including enhancing or modifying or annulating sections of the order. Subsection 2 then casts fetters on the powers under subsection 1. My lords, in this case,
The appellate authority, having taken into consideration all the facts as well as law applicable in this matter, has given a decision. Worship may kindly take to page 83.
No, we want instructions. DG accepts notice.
The statute clearly grants the powers.
Let us see, let him get instructions, whether it falls under 108 or it has to go for an inquiry. We'll see.
And moreover, the interpretation issue involved in this, what is the scope in which the power under 108 can be exercised in respect of an appellate order?
DG accepts notice for the respondents. List the matter on. Fifth.
But in the interim, some protection will be granted by law because demand has been raised here. Further penalty has been also been levied on it. The appellate authority has clearly given the relief by law. Therefore, the question of whether this is an abuse of power under 108 is to examine the issue.
He has a benefit of an order in his favor before the appellate authority.
Issue. Page 111. Page 111 ballots. Further revised demand has been issued.
We'll stay this till the next day.
Now, the appellate authority having given me relief, any remedy here shall only like further appeal balance. 108 cannot be appealed in this manner to deprive all the petitioner, all the assessees got relief from the first appellate authority. In the absence of tribunal, appeal is there. In this case, it is in my favor, balance. Any payment doesn't arise.
And against the revisional order, against the revisional order.
I'm questioning the very validity of the reasonal power exercise in this balance. Because the appellate authority having been in my favor, it is the revenue which is agreed. It is agreed, it should go in tribunal, go and appeal before the tribunal, not me. Payment doesn't arise.
No, that means that. No, that is a matter that has to be heard whether the scope of. But in interregnum, you deposit 20% of the fee.
Tax was already paid in full. And then it was refunded to the order of the first appellate authority. Question of fee paying doesn't arise because this case, the first appellate authority, which is the acting authority, has given relief in my favor. Because the question of
Let us see, just hold your hands in the next issue.
Taxability does not arise here in this case. That is the whole question. And whether 108 can be applied in respect of an appellate order. If 108 can be exercised in respect of an appellate order, then what is the use of tribunal here?
That's a matter that we'll have to go into and hear. Whether it falls or not is a matter to be heard.
Yes, sir.
Otherwise, we'll have next week. We just have a look at it. We'll have it on 28. Insofar as the intermediate look at it.
Having secured a relief from the first appellate authority, my lords.
We'll see orders list on 28th. Yes. But yesterday some other matters. So we'll have it 28th. Third counsel Sri Sushal Tiwari. Dilip accepts notice for the respondents. This is the matter in the preliminary hearing list along with.
I'll give the number.
Along with WP number, so it's on 28.
Number 7.
28. Yes. No, this some similar matter had come up, isn't it? Similar matter. Rent a cab, somebody had come.
issue where the erstwhile just to review your on the export of services will be entitled for refund of the interest. They will calculate your the refund depending upon the formula that is there in the rules. We'll have an export turnover. Suppose you want to see a bank reconciliation. That's not the
Kumar.
if file a refund, your also they reject it on the ground that the original claim your also under the service tax is rejected. That rejection your also is on the ground. Your export turnover is the wrong calculation, not on the accessibility of tax. So what we did here also after the Supreme Court order came, enabling us to file a revised return. We filed this revised return, including this amount also. That he rejects it again, your so refund is rejected. This also is rejected on the ground here also that original claim for service tax is rejected, therefore Prime also will be rejected. But it was not the correct. Whatever credit will come back, that credit we can transition through the planners under the new.
This who appears for central tax. Who is central tax?
Number one is number one.
What about Deputy Commissioner of Central Tax? Non-council G1 is directed to accept notice for the respondent. This is the matter week after next. Week after next. Get instructions and complete applications. Objections to be filed by them. You take out notice. Take out notice. Income tax. Sammati accepts notice. It's the matter week after next. Statement of objections to be filed within 2 weeks. Refund. Refund no delay. Refund no delay. No, let us see. Let us see. After the file, you move it. You first move him, ask him to file objection, move Sanmati. Force him to file objections and move the matter. Don't leave him. Don't leave him.
Number 9. We are a private limited company making the business of construction. So in the month of
Just 1 minute. This is covered.
we pay more than 10%.
You've already paid.
Yes.
No. So where the interim order in other matters?
I have a question.
Still it has not been taken up before the apex court.
3997.
Council. AG accepts notice for the second respondent. Second and fourth. 2, 4, 5, and 6. Madan Pillai for R1. Then what about GST Council? GST Council. Non-council G1 accepts notice for the second respondent. For third respondent. Petitioner is permitted to correct the spelling of the description of the third respondent. You carry it out now. It's council spelling. ಇವಾಗಲೇ correct marks. ಅದೇಂತ Land Council for the petitioner submits the petition involving similar issue has been entertained and interim order has been granted. Reliance is placed on the interim order passed in WP 8548 of 22. In light of the same, taking note of parity, there would be a stay of annexure K1 subject to deposit of 10% of the tax assessed. Full stop. Petitioner submits that 10% of the tax assessed has been paid. More than 10% of the tax assessed has been paid. The respondents to verify. You must not leave till the judge gives the interim order, even in a matter where he is not going to give.
लाइव कैसे पता चलेगा?
So same as in the previous matter. Oh. The order passed in
10/76/2021, based up to 9. Covers payment of GST or on grant of mining lease by the petitioners into the next state.
same order.
It is granted in some.
Who appears for the respondent? 2-2. No, AG accepts notice for respondent 2-6. One is accepts notice for the first respondent. In light of the submission that Apex Court in WP Civil 1076 of 21 has passed interim orders. In the present matter also, as a question, identical question has arisen for consideration, payment of GST for grant of mining lease/royalty shall remain stayed. Insofar as royalty is stayed. Yes. It's Canada. Yes.
Eight ideas, 8 classes on a and different tax rates are respectively 11, 12. Now, department issues notices to 4 of the 4, they are getting all the numbers, they should as 4.
Give him a copy. Yes.
Now, blood, 4 so issues notice under 1 party. But 2 things, they say the income to be assessed at the 4 co-owners. The 2 co-owners and they pass an order to the 143 SSS. Accepting it belongs to you or not belong. For this person, after you should notice you are only 1 co-owner, they assess all the 4 co-ownership. So that aim of assessing is wrong, assessment is wrong, Notification is wrong. Approval is wrong. Everything is wrong. What you will see that they are regularly assessed to tax. The main tax is increased from 2002. We find that at the point of time in 2011, the Karnataka High Court called Trial, in which we long contemplated to pay tax and take a entry. The government of India brought a scheme. 2000. The regular branch we applied to pay the taxes as per law at that time. Now what they are saying is in this individual, they are giving credit to what they pay tax there. Now they have taken the complaint that they have got the government taking a letter from it. This court will take a center itself has categorically held that a letter from the government cannot be the basis of application. First they are saying number one, now they are saying all. We are saying it the chair, they are accepting it the chair and reducing what I offer in the chair. How the same transaction, half on the chair, half on the individual. Apart from that, my lord, the authority, the lordship are aware now beyond 3 years, it will be 680 years.
No, approval. Approval, what do you say? Approval.
There is no notice. I show that pending but after the pain, letting take exception, it will ask me to open. Any day can. But here is the case where for 3 people, 2 people they say not income. I placed the order also, madam. The lot of see. I placed the order to wife and the son. Then they accepted. After this, that page number. How many days? They agree. Both son and wife. 240 email. You want to see very same transaction. They issue notice to 4 people. 3 people they accept, 1 they add. It's the lot of 238 and 243. 238 is the wife and 243 is the son. And in that 238, I even informed the officer. The base is getting accepted in the case of Narayan Reddy income. 238 is the order. The lot of 242 million income. How can the same income be assessed in 4 hands? We will make a demand. Computation is wanted in the business of court. The business of court also applies. Page 251.
Otherwise, you want to have it next week, we'll have it next week. Let us see next week.
I will appeal next time. Yes. Because state will next year appeal. Renew on the issue of legal, you are not to the meeting. 1836. Below.
Incident counsel appearing for the petitioner submits that the approval ought to the approval ought to have been in terms and by the authority under 151 Roman 2. And it is submitted by non-counsel identical order.
On the issue of
It is submitted that notice and the contention will remain till the end. If the earlier, no, if it is. No, I'll have an interim order till the next date, then we'll 148 notice and the proceedings pursuant to that. We stay at the 148 notice and the proceedings thereto till the next date.
Actually, I don't suspect.
Yeah.
Where? Actually, A1 now. A1 and consequently.
Right of way contentions raised, including regarding that approval from the competent authority had not been taken. In terms of 151 Roman 2, there will be an interim order of state in the next state. This is the matter in the orders list on 21.
So,
2 weeks. The respondents are at liberty to move the matter after filing statement of objections. Yes. Central Board of Direct Taxes. Third Council. He is appealing. Third Council Shri Dilip is directed to accept notice for respondent 1 and 2. So only, I mean, the adjournment request has been rejected. 150.
Request 16 May 2023 member, taking time up to 3rd May 2023. And the next column over status, so status or action open.
Now when
Essentially, my request has also not been considered or not rejected, and directly the order has been taken. That is my grievance.
order at annexure,
Section A1.
so where do they refer to your adjournment application?
For reference column. For at page 56.
Yes. Annexure? Yes. Yes.
Of responses, the notices and responses, the last item there.
Yes.
It is 9.5. Date of complaint 765. Response of the assessment.
Can you send it back or? Huh? The respondents not to take any precipitative action to the next date. List the matter in the preliminary hearing list next week. 28 too many matters. 5th July. It's only rejection of refund, isn't it? Also, you take. What? Where is the order?
Page 17 talks about it.
Page?
Page 17.
Now, customs and central tax. Land Council G1 accepts notice for 2 to 5. Land Council Sri so and so accepts notice for the first response. Page
17.
17. Annexure A.
We have claimed 1,39,154. Then according to valuation, it's 1,39,149. So the difference in amount is 2 rupees extra.
So where is the reasoning? Take me to the reasoning portion.
Para 9.
Page number 80.
Page?
80.
You take notice. Land Council G1 accepts notice correspondence 2 to 5. So and so accepts notice for the first respondent. This is the matter week after next. Yes. There's no interim prayer, isn't it? No. Oh, what interim prayer? No. A refund has been rejected, isn't it? Oh. So then why you then why you wanted time? No, that's okay, but if there's something adverse, I would have intimated. Yes. Land Council Sushal Tiwari accepts notice for all the respondents. For all the respondents. What is the matter?
Assessment order as well 148 as well 148 AB, AD and 148. Basically, my lord, 148 notice was given after 3 years. We have section 149 only of that. Escape to the income 50 like it is more than 50 lakhs. It says admittedly 148 AB order, 148 AB notice, 148 AD order discloses only 38 lakhs. My lord, according to the department, that is escape. So my lord, please see page number 87, my lord.
No, correct, but no, the only point is Sanmati has raised a submission in the previous matter saying that suppose there's any defect in the 148 AB notice or AD and you wait till the assessment order is passed, why we should enter into that at this stage when a substantive remedy is available? That's his contention. Now, suppose at the initial stage you come, we can stop it there itself. But if you wait till the assessment order is passed, you can take it up in appeal.
In this case also, my lord, single type of
No, that's there. But now assessment order is passed. So what they are saying is you take up substantive in the appeal only.
Because here again, the violence of actually, in fact, my lord, it's not the motive other than the assessing, my lord. What is the again the last assessing before the assessing came to know by opening the portal that he has been my lord. Subsequently, filed to the last we updated the email partnership on that one partner is discontinued from the partner we retained from the partner the year 31st March 2017. He left us on the email ID, whatever is there, he never used to look into that email matter. So consequently, these partners, the remaining partners, not aware of the entire thing.
No.
Today they were came to to know, my lord. The filed on assignment letter, my lord, seeking time to pay the receipt, my lord. Subsequently, without considering that the assessment order has been passed. On that ground also it has to go, my lord.
Then you can now
All open.
page.
Dispute on this matter, we are logged in 26/4/23 matter and updated the email ID. Because of updating the email ID, only we came to know that notice matter. You see the contact portal matter. In that right number 1. Please see page number 176 matter.
Yes.
Page number 176 is the personal detail in the e-filing portal, my lord. The email ID is updated, my lord, on 6/4/2023, my lord. What my learned friend referring is on 2/2023. After me, updating on e-portal, I received this information, for which I request to gather the information when I am trying to log in on 50, my lord, when the focus notice was given. First page number, contact portal, my lord, page number 176.
Yes.
76. So the updated last line, last update is April 20. The assessment came to know through his authorized representative, my lord. There is a proceedings on that. He came to know on 6 April 2023. Immediately he updated the email ID of the total partner at Murli KM78@gmail.com, my lord. Then they received the focus notice, my lord. The focus notice is at page number 167, my lord.
Yes.
Page number 167. The focus notice, my lord, dated 27/4/2023. On the focus notice, please see it was signed, my lord, on 27/4/2023, 9 to 10, my lord. You can find it at page number 173, my lord. Page number 173, last item, my lord, digitally signed by assessment unit, income tax department, date 27/4/2023, 22/12/18 IST. It was signed on night to 10 o'clock, my lord. The given time, my lord, which is the page number 173, lost. Page number 172, last not is there, not even 4 days to file reply. So on 2/2023, when the assessor wants to seek an attainment, the portal was then he filed a letter at page number 172. On May 4, 2023, he filed a letter before jurisdiction nursing officer, my lord, they explaining the entire thing, my lord, and he was seeking the attainment. He did this letter, my lord, contain a whole thing about this case, my lord. Here in receipt of the focus notice dated so and so, the assessment unit, then the follow proposed to make correction of so and so. We get to submit the following for the time consideration basis favorable order.
Then what happened?
My lord, this was filed on 8/5, my lord. On 8/5 only the assessment order is also passed. On the very same day, my lord, assessment order is also passed. Here, my lord, there is a legal position, my lord. The focus notice, the minimum 7 days time they have to give, my lord, as per the SOP, my lord. The standard operating system, my lord, dated 3/8/2022, my lord. The 11th portion, my lord. The last page, my lord, my lord. Process of assessment focus notice, my lord. The last but one page, the last line, my lord. Also, global notice shall be issued in the prescribed format in all cases where any variation is opposable. In that, my lord, they are given N 1.3, my lord, to ensure adherence to the principles of natural justice and reasonable opportunity. Time limit should be given for obtaining response to FTA shall be response of time of 7 days from issue of FTA. This is admittedly only maximum 4 days time has been given by that. The minimum prescribed time is at least the minimum 7 days they have to give.
We'll state the further. We'll have it in the preliminary hearing. If it is made out on this ground, we'll set it aside and remand it back. Otherwise, we'll have to hear.
And even the approval also, my lord, in this case, the approval of game of my lord. So,
The petitioner submits that the show cause notice him to be issued as per annexure.
That is annexure, first only 148 notice, my lord, annexure D4, my lord.
No, the show cause notice you said after updating your.
Focus on annexure H, my lord.
At annexure H on 27/4/2023, calling upon reply to be made by
Second, my lord.
2nd of May. It is submitted that in terms of the standard operating procedure applicable issued by the National Faceless Assessment Center as per N 1.3, response time of 7 days is to be afforded, subject to certain just exceptions. It is submitted that the petitioner had sought to take time on 2nd of May, but as the portal was not accessible, petitioner has made out a written requisition on 4th of May, which has not been considered. Subject to further consideration, there would be stay of
Annexure A1 to A6.
E1 to E6 till the next date. Respondents are at liberty to seek for modification of the intent prayer on filing statement of objections. This is the matter in the preliminary hearing list. 2 weeks one date for it. 5th. Next. 11th, 12th. Can I know? Change of opinion.
Yes. One of the arguments.
Just one. The Council Sri Sushal Tiwari accepts notice for respondent 1 and 2. Section
149.
limitation.
Yes.
You've given a copy.
The multiple grounds for the purpose of interim order, only this perhaps is.
Yes.
Section 149, my lord.
Yes.
Time limits that are prescribed, now it is 3 years and 10 years. And you see the proviso.
Yes.
Provided that no notice under section 148 shall be issued at any time in a case for the relevant assessment year beginning on or before 1st April 2021. If a notice under section 148, I'll skip the rest, would not have been issued at that time on account of being beyond the time limits specified under the provisions of clause B of subsection 1 of this section, that is 149(1)(b), as they stood immediately before the commencement of Finance Act 2021.
My lord, may kindly see 149 1B as it stood earlier, which is in the previous page. Previous page footnote 149 1B says no notice under section 148 shall be issued for the relevant assessment year. B says if 4 years, not more than 6 years have elapsed from the end of the beyond 6 years, notice for any assessment year before 21, April 21 cannot be issued at any point in time. Can you see the notice under 148 in this case? Assessment year.
No, this is a transitional provision.
Transition benefit given to the old assessment years before the amendment kicked in. They said that you cannot go beyond 6 years in any event, as far as those assessment years are concerned.
So that benefit is protected.
That benefit is protected. From a lot of can you see assessment year involved is 2016-17. 6 years elapses on 31st March 2023. Kindly see the notice, impugn notice.
Page?
Page 135, annexure L.
Yes.
17/4/2020. On this point itself, of course, I've taken change of opinion and other things. They're straightforward.
So we'll stay if you take notice. The non-senior counsel appearing for the petitioner draws attention to annexure L, notice under 148, which is issued on 17/4/23 for the assessment year 16-17. It is the proviso to 149 is pointed out. In light of the same, taking note of the limitation under the section 149 prior to amendment, period of 6 years is to be the time permissible for issuing notice. The present case as the assessment year is 2016-17, period of 6 years would end as on 31st March 2023, and as the notice is issued admittedly after the period of 6 years. Matter requires consideration and interim order required to be asked. Accordingly, there would be an interim order of stay of annexure L and proceedings pursuant thereto. Sishanti Vihari accepts notice for the respondent. The respondents are at liberty to move the matter for modification of the interim order after filing statement of objections. This is the matter after 2 weeks. 12th July.
The notice under section 148. It is at page 435, annexure J, dated 24/2020.
What is this matter?
Again, challenging 148 proceedings. I have taken a ground. The information they say is that I have they say certain share premium, certain premium that I have received is unexplained. This premium basically is I have issued CCDs in the year 2010. So have been converted in this year to equity shares. This year 16-17, they say that this premium that you have received is unexplained. If at all the adjustment has to be made in 10-11, that is the point I have made on merits. But for the purpose of stay kindly see the 148 notice. Assessment year is 16-17. Notice is issued on 24/2020.
Which?
Page 435, annexure J.
16-17.
16-17, 6 years expires on 31st March 20. Notice is dated 24-25.
How if the preceding procedure of 148 capital A that is issued within time?
The 148 AB is before 31st March 20.
So the bar
And
comes
the proviso says no notice under 148. The
148.
language of the proviso is that. They don't say proceedings under this 148, under these provisions. The language is very clear. Because no notice under 148 can be issued beyond that time.
No, sir. So my point at subsequent stage to be considered is suppose there's an inquiry
Yes.
and the 148 AA or AB notice is issued within that 6 years. Then whether it would save the 148 notice is
They will have to amend the provision. The way the proviso reads now, that view perhaps cannot be taken. If perhaps the proviso they had stated that the proceedings under 148 or 148A cannot be initiated.
just read it just for the sake of info.
Yes, sir. The proviso says, provided that no notice under section 148 shall be issued at any time in a case for the relevant assessment year beginning on or before.
So all the three, according to you, must be issued before the expiry of
148
6
has to be issued. So procedure has to be much.
So now the identical order is in the last matter. Reasoning also will be the same.
The first ground I am urging, of course, I have other grounds to urge, I am not getting it.
Same order till the next date, same. Respondents are at liberty to move the matter for modification of the interim order or for hearing of the main matter upon filing statement of objections. But that one position of law you examine, all of you examine whether the bar under the proviso will have the effect where 148 AA or AB is issued before the expiry of 6 years. Whether the final 148 notice which is issued must also be within that 6 years or not. So their contention is even if you issue the earlier 148 AA or AB notice within the 6 year period, it will not save the 148 notice if issued after the 6 years under the old provision.
You cannot invoke the extended of 10 years. CS has lapsed about the for prospective bar. You cannot invoke the extended period of 10 years. Because 60-year term, that is the protection by the more reducing people that cannot have any effect at all. He refers to being an office because of the extension of 60 years. The cause is dead before the amendment. You cannot revive it even after the amendment. But I think there is a 10 years. That is the entire issue for that is as of 1/4/21. There's under the old provision, comment done. One of the possible arguments is of taxation all the limitations got extended after that is.
So that will be added. That will be added to that.
Before expiry of 30th June 21, the revamp coming before expiry of 6 years, but 6 years instead of March before expiry of 6 years, you cannot reach to 31st March, you have to be 30th June. Before expiry of 30th June, revamp has come in. Now there is a continuity. But this is the view taken over the delay. All those conditions reduced for State with the but Delhi High Court judgment is not available. This is the even what is no here.
Let us.
That's on a slightly different point.
Huh? Let us.
The entire purpose of provision of the is to have a photo 21. If I could have an extension with Delhi.
Let us. Yes. Yes. Council Shanmati accepts notice for the respondents. Yes.
The deposits in the bank, holding the bank, permission statements that are in Kannada, the English language. And I have published the receipts and payment, all the details that were called for published. And he accepts my return of income denying me the ATP deduction. The bank accounts are reflected in the bank return of income along with the statement. And he considers the deposits made in the bank account as income of money.
Now next week. Huh? Let us see. Have a look at it. If it requires, we'll send it. Relist the matter in the orders list on 5th. Yes. No. Petitioner to furnish soft copies to the respondents. Yes.
In the 148 notice, there is an and the pay as and the pay. But the notice termination, the challenges are different though, because they are not followed. And the state of the same for the assessment year 1780 and 1890.
Yes.
No, they are not taken. But you are okay. I will read 149. No notice under section 148 shall be issued for the relevant 3 years back from the end of the relevant year. Under of last year. Last period is 3 years, but not more than 10. However, from the end of the relevant year, under certain copies as only possession of or other document or evidence reveal the income chargeable to tax represented in the form of asset as is a asset. Amount due are likely to be.
No, then we'll call this along with the other petition and discuss.
Other petition is also clubbing.
It is there, is it? No, but 2107 of 22, annexure B,
975.
no, correct. Now at page 30, the interim order as regards the 148 notice refers to WP 2107, page 30. That means there's another writ petition challenging the 148 notice. Different for same assessment here. Same assessment here.
Assessment, yes.
Same. Then we'll have to.
He has reopened. He has reopened in the name of 17 and 18 because these were two restricted or the issue of family members. And they have joint development agreement and they have sold the flats. So, according to them, they have sold the flat. The capital gain, they have wanted to assess the capital gain. They have disposed also. They have disposed it in the year 1718 and 1890.
But then the petitioners are different.
Petition is same.
But the present petitioners who petition are related to us. She is altogether different. 1718 what is altogether different. There's no maybe arising out of the same transaction, but the cost of the opening is altogether. If I permitted not to say 1718 what is the dispute, each year the capital gains has to be assessed.
Yeah.
But the assessing contended saying that for assessing in 1617, they made an investment of 80 lakhs. Not for acquiring the asset. In 1718, that 80 lakhs has to be allowed as a cost of acquisition. Now 1617, the assessee has not declared or extended what is investment of 80 lakhs. On the basis of their own admission that what they have expenditure of 80 lakhs in 1617 has been reopened because 80 lakhs are not as a state assessment. Now the only ground in 1617 is it is less than 50 lakhs. Not the expenditure not what they have done is 80 lakhs. 80 lakhs that is it. 1718 has no.
Let us forget about the 1718. The stay is not there. Let us come to section 45(5)(a), section which has been amended and has come into force only in the year 2018. 1/4/2018. I'll read it.
No, before that you go to the 148 AB notice. Let us have a look.
The AB notice.
Page.
AB. Here you are you see. A is the order. A is the order. Page 50, 48. At page 55, you lordship find it. They have reopened it. At page. So called notice under section A.B. of the Income Tax Act of 1901. Notice under section 148A was issued with regard to
You're reading at page
55.
55 is the computation of capital gains.
This is AD, your lordship. Order.
Correct. 55 is a computation of capital gain.
Yes, computation of capital gain.
Starting from page 54.
Oh, here, 54. But I'm going to point out only this. This is under 55. Show cause notice under section 148A of the income tax. The next video.
Page number is at variance. Which annexure?
Annexure A. stay.
Yes.
Find your logic. It is further observed the occupancy certificate of the building was signed on 24/6/2015. As per section 45 within brackets 5A of the Income Tax Act, where the capital gain arises to assessment from the transfer of capital asset under the specified agreement, the capital gain shall be chargeable to income tax as income of the previous year, in which the certificate of completion for the whole part of the project is issued by the
The page number,
competent authority.
page numbers don't tell.
Yes.
Huh? Wow.
Reading from the statements.
Yeah, repetition. 9724. And first note. So this is which writ petition? I am looking at. Then just wait. I was in the previous writ. Annexure J, page 50. That is the order under 148 AD. Yes. Yes. Cost of undivided share of land.
Next page. One page up. One page up.
Yes. Yes.
Last word we can.
Yes.
Yes.
As per section 45 within bracket 5A of the Income Tax Act, at the middle of the paragraph, where capital gain arises to assess from the transfer of capital asset under the specified agreement, the capital gain shall be chargeable to income tax as income of the previous year, in which the certificate of completion of the whole part project issued by the competent authority, and for the purpose of section 48, the stamp duty value from the date of issue of certificate or the share be the building. They want to assess capital gain in the year 1670. In the year 1670, taking into account 1718 and 1819, the expenses are expenses.
Now the capital gains is to be calculated in which year?
Calculated for the assessment year 1670. But on the basis of
Standing of the year. If they that 18 lakhs.
In 1617.
Acquiring this. Maybe I get something.
we are not paid.
Now the assessing officer is looking at some that 18 lakh or 1617. Because private has a cost.
Now they gave the reply. That has been considered in this order or
Less than 3 lakhs. Beyond the period of 3 years. Because it is 80 lakhs of the place. When
Apart from this, apart from that, whether
will be allowed in the year of price.
Now, what has happened now?
your object. This is, they want to assess the capital gain on the basis of the section 45 by A, which has been introduced from 1/4/1980. They want to reopen 1617. I read the 45A.
No, no, what is the stage of the reassessment? Whether notice proceedings
Notice has been issued 148.
proceedings yet to commence.
They are not on.
They-
It's not on the year of access. In their return, they claim 80 lakhs. Whether the 80 lakhs investigation has taken place. Only for. The last was the legal case.
Which page is that now? Cost of BW assessment.
It starts with one cost of legal case.
Yes,
Next page was
yes.
the last of one. Sufficient statement assessment. Sufficient statement assessment. After the information between the property is after the implement of party from going on that and distribution institution is made. Head of audience. The transaction. Yes. Seventeen, 18, 19, they are planning to have planned an expenditure of 80 lakhs is allowed as a reduction. That could not be justified in those years. Hence, not whether actual expenditure has been incurred or not, whether it has been accommodated or not, whether it is. But that has to be obviously examined.
No, but could you not have made an inquiry under 48 AA?
That's what inquiry is made, they have not substantiated.
Each year of,
Otherwise, what happens? In 1670, if the actual expenditure has not taken place at all. But in 17, 18 or 18, 19, we will allow that 18 lakhs expenditure. We cannot examine whether 80 lakhs has been incurred or not in 1670. Why am I not conducting a 17, 18, 19? Once we accept not in 16, 17 that 80 lakhs expenditure has been incurred, then automatically they are taking more than 17 lakhs. I think the only scope of work that we student. Whether 45 by day, whether in the year of JDA or in the year of that will arise only in the year of sale of those or the year of JDA.
Where is your reply? Let's have a look at your reply. Your reply to the 148 AB notice. Annexure? Annexure F is the acknowledgement.
He proceeds in response to that acknowledgement.
Yes.
Your lordship, we must respond submitted down below the water. Reference to the above notice, cited complete attention to the fact presentation of the following ground and information. As per your notice, besides alleged escapement of income does not pertain to equality as detailed below. Date of sale, please assess the year 25/11/2016 and 17/18. Respectively, the alleged escapement of income of improvement claim for the assessment year 17/18/18 does not exceed 50 lakhs as per subsequent new section 149 as detailed below. Income tax at the following.
No, but wherever you demonstrate is less than 50 lakhs.
Yes.
Hmm.
Your lordship. Good point. This, your lordship, date of sale, what it says is the specific 149 is like this amount which has escaped the last line of the 149A, your lordship.
Yes.
Which has escaped assessment amount of 2 or is likely to amount to 3 lakhs rupees or more for that year. For that year, each year is different.
No, but however you demonstrate is less than 50 lakhs.
Yes, I have filed my return that I have 17/18 I have filed, 18/19 I have filed. Stay has been obtained, the lordship finding. I will, because it is a history of property. It is a history of property. Both, there are 3 brothers, 1 father and 2 sons.
But your response must make out that. Your response is not made out that.
It has been, yes, because 17/18 and 18/19, I have filed my return, which has been into a copy of the statement of income that has been enclosed as the rectification 2107.
No, but did you place this before the authority along with your response to the?
I have raised. I have raised because.
Where is the reply to the 148 AB notice? We'll take it up. You just correct the page numbers. We'll take it up. I'll pass over and I'll take it up after lunch. We'll take it up. You just correct the page numbers in yours so that when you're referring to the page number, it tallies. Pass over. Yes, next. After 2:30, we'll take it.
Rejection of my application to issue error reduction under section 197.
Yes. So what is the?
Yes, it's required. Here also,
Not, I mean, yes, I mean, not have a bearing on this matter.
Let us see, let him file his responsibilities.
Or, you know, they take eternity to file on this matter. I think to be protected interim.
That will
By
protect.
directing the SC officer to allow me not to make receive payment without reduction of tax. So that's what generally
that is
the
the
department.
Huh?
That is the final thing.
So what happened, my lord, the last financial year I made an application. That was rejected and they took about 6 or 7 months to reject that.
No, now you,
By which time the financial year was over and tax has been deducted, I have a refund of 2 crores from the department. All that I am saying is, point is very simple. My point was very simple. That my estimated income for this year is going to be a loss of 200 crores. So I am not liable to pay any tax. Therefore, please allow me to receive payments without deduction of tax, because tax is deducted. My working capital is getting unnecessarily stuck with the department. Last year, almost 2 crores of refunds are due. This year, estimated tax deduction is about 4 crores. These monies will be stuck with the department until I file a return and assessment is done. Therefore, all that I am saying is, please issue me a nil deduction certificate. The assessing officer rejects my application saying that you have not complied with Rule 28AA. It says that I should produce financial account or financial statements of the last 4 financial years. Now, I am the company which was incorporated only last year, but I started business functioning last year. How can I produce financial statements of the last 4 assessments? If the provision, our rule is read in that manner, it becomes odious. Any person who has not started business for 5 years before cannot even make an application.
where is the order? Where is the order now?
Order, my lord, is that Annexure D, page 44. And what my learned friend is saying is, there is another, I have another group company against which do not one proceedings have been initiated on the ground that they have not deducted taxes. The proceedings, they have filed the rectification in the state, this honorable court was issued that state. Assuming, my lord, that they are liable to they are liable to deduct tax and the demand is foisted on the group company. How is that concerned with me? Can that demand be collected from me?
Now,
Legally, my lord, there is no provision under the act.
no, at Annexure D, what is the reason that is assigned?
Annexure D, kindly see para 1. The applicant company was incorporated on 9/3/2021. It means my first financial year where I had certain transactions was 21-22 financial year, 22-23 assessment year. Has started its business operation effectively only from Q1 of financial year 22-23. Hence, its accounts are not before IT authorities. In this case, there is no guidance of any precedent. Therefore, it is not possible to examine basis of estimation allowability under that. Further, any assistance of Rule 28AA of the income tax is not available in this case. It is clear from the above that application submitted by the SSC company so does not fulfill the requirements, conditions, criteria as laid down by Rule 28AA.
No, now,
28AA says I should file. Rule 28 only says that he should give me a certificate considering.
now you file,
So things.
now you file your objection by 2 weeks, I'll fix a date. And then we'll go.
Not my kindly dispose of the matter, otherwise my repetition becomes infructuous. That's fine.
Now, when is the next deduction?
But the payments keep on coming from 1st April.
So
All the payments that are coming are taxes being deducted. Now, all that tax is in the department. Ultimately, I am bound to get a refund. But I cannot get the refund unless this financial year assessment is over. I file my return and they do an assessment. Why should the money be stuck with the department? And very clearly, I am a loss-making company.
We'll fix a date. We'll do. This is the matter on. When do you want it? This is the matter on 5th of July. Statement of objections to be filed by the other side. Yes. Same. 6th in the same stage. Yes. But if it requires detailed hearing, we'll have to. Let us see your response. Yes.
Matter where the date filing B, section 234, capital B,
234.
B of that.
Yes, Dilip.
128
A12.
across 200.
Yes.
Bench of this honorable court has very held that the periods prior to 1/6/15 his rate filing fee under section 234E could not have been determined and demanded an intimation under section 200.
Page.
147 onwards.
Paragraph.
Relevant page is 7. Para 23. 24.
Page 150. Paragraph 24. Read.
The facts of the presentation are examined. Yes, in all matters.
Yes, what do you say? Yes. Yes. This was introduced on 1/7/2012. Yes.
The statement referred to Yes. But he has to find a number, he has to find a return of TDS return, positive number of TDS. But why it is that it was even on what it is, but unless the detector finds the return of the credit could not be given to the detector. Because of the delay not caused by the detector, not uploading the TDS. But under 26 AS, it automatically the credit was not available to the detector. Hence, what the detectives could not be given benefit. But when there is a delay, and it has to be redone, to avoid the parts to the detective, this penalty has been brought in, where the key amount has been brought in. As a privilege, what has been the construction liability of this challenge across on the ground that but the assistant contested saying that there is no need for charge. But all the high court it is for a privilege to file TDS return beyond the statutory period. Hence, not it is justified. Now, another contention was raised about the division of single letter before the division, one more issue was raised. But that is under section 200. There are some relation with page 111. A statement of fact, a statement of fact statement shall be processed in the following manner. But this is calculated the return is 5 now that the regular return. So the intimation will be issued to the similarly, when the return is 5 under 100. So the intimation will be issued to the knowledge is the return. But then it is if there is a delay beyond the right, that is not giving us. A fee, if any, shall be computed in accordance with the provisions. But this you also can notice it came into effect from 1/6/2015. But what the division bench of this honorable court has held is, by virtue of 2012 amendment, which is a charging section, you have a right to levy. By virtue of the machinery provision or demanding that or quantification has failed to not include by 15, that is 1/6/2015. You have no authority to make a demand prior to 1/6/2015. Doesn't speak about Indian assessment years.
Because C was introduced only in 1/6/2015.
All the demands was made in the absence of C. He was brought in one of the noticing that was the validity. That's why when the division of this honorable court has said saying that revenue has no right to demand
Prior to
1/6/2015.
for late filing of 200A.
Whatever notice already we could not raise 1/6/2015. Whoever not assessing have already wanted to pay that amount, but was protected saying that they cannot utilize this. Years for prior to 1/6/2015 cannot be read for as an assessment years prior to 1/6. Because the charging section was there, those are 12 years. And that has been applied. If I have made a demand for prior to 160,000, they have that not said but in this what I have noticed, there are some more we need to be possible. Any question afterwards.
So then you make a list of which are those which have to go. We'll have it on Wednesday. You make a list of which of those, according to you, issued prior to. Huh?
Yes. Which one of the picture?
There are many players
Visually available.
Page.
section A1 will go, A2 will go, A4 will go. In that one, assessing your financial year 1230, that A3 will remain. That's all. Similarly,
But the out of date of original processing matter. Page 50, connection A3. Page 50.
No, then now you just have a look at it, make a table, and then we'll dispose it. And remaining whatever is to be considered, we'll consider.
may have one point.
Yes, ma'am.
Functional integration is based on rectification is not. Because the original depends on part of these ways, but the rectification may be. That date cannot be, you may not correct. The government has to disclose what are the original integrations. What are the notices issued prior to only? What are the notices?
So you make a table, have it next.
Reading the it says in respect of period prior to 160,000.
That we'll see. That we'll see. That we'll see. For the remaining, we'll see what is to be done. Whatever goes. The remaining we'll keep it and we'll get it.
Bunch of matters. All matters. Various. Yes, all record. This because I had the benefit of you have no demand, you have no right or power or demand prior to all.
Because it was inserted only then.
But that has to do with
Correct.
Yes.
That's how it will have to be construed. So you make the table, let us.
Because once the charging section for something to post 2012, machinery provision came in 2008. The charging section cannot be postponed to 2000.
Yes. Relist the matter on. When do you want it? 5th. 5th in the same stage. There is an interim order, is it? Interim order earlier granted is extended till the next day. Yes.
Matter of this petition is pertaining to safety of the in fact, reading the petition is the petitioner company was submitted to corporate insolvency.
Yes, income tax. This is the first time it's coming.
First time it previously it had come for compliance office.
Yes. So what is the case now?
Case is about this petitioner company was admitted to corporate insolvency resolution process by Anantara in the year 2019. Subsequently, a successful resolution applicant came forward and submitted a resolution plan, which also came to be approved by the NCLT Bangalore Bank in the year 2020. Now, Section 31 says any claim, whether it is statutory dues claim, per period pertaining to the approval of the resolution plan, that stands. That is as per Section 31. This has been applied in Ghanshyam case. And in similar matter, Honorable High Court has granted it.
Correct. Now, what the contention that is being raised now is that there's one more judgment of the Apex Court and Rain.
That is only if the statutory department becomes the secured creditor.
No,
If they are stepping into the shoes of the secured creditor and it has not been addressed in the resolution plan, then that claim has to be accepted. But that is not the case in my case.
But that you'll have to just point out. The submission that was made was by virtue of Rainbow. The authorities will have to be equated to that of a secured creditor. What of it? Rainbow. NCLT. Rainbow.
Para number 57 of the Rainbow judgment.
Just one. Sandeep, you made some submission that day, isn't it? No, whether after the resolution plan has been approved, now does it ipso facto? Now they were a part of the resolution plan, the department. And then there ends the matter.
Actually, in Rainbow, Rainbow interest has there is no challenge to the resolution plan.
No, correct. But maybe Rainbow applies where they are not a part of the resolution. That is by operation of law. That's how they interpret it. No, correct. But now in your case, you are saying they are part of the resolution process.
Part of the resolution is statutory creditors were.
No. In the present case, they are part of the resolution process.
They are not part of the committee of creditors, but their views have been acknowledged. Nothing has been credited to the account.
So then what happens if the plan is silent?
It stands extinguished. Because they are not a secured creditor. No security interest has been there.
So then we'll state and then you take your stand. It is. Where's the resolution plan?
Resolution plan we are addressing the 8110. We find next the page number 15.
Okay, then we'll refer to Ghanshyam Mishra and we'll grant a stay. And then you file your objections and take your stand. So what is the interim order you're seeking?
In order, I'm seeking stay on next 3 and then demand notice. That's the matters that lots of pay to create a collect. The order has been passed. Page number 58, annexed. Petition number 811021.
The petitioner has sought for setting aside the demand notice under 143(3) at annexure E and F, E and F,
Yeah.
contending that by virtue of the acceptance of the resolution plan, as is evident from A or B, as is evident from the order of
White
NCLT,
order 24th August.
order of the NCLT dated 24/8/2019, the right to demand gets extinguished. Reliance is placed on the judgment of the Apex Court in Civil Appeal 8129 of 2019 in the case of Ghanshyam Mishra and Sons Private Limited through authorized signatory versus Edelweiss Asset Reconstruction Company Limited through the director and others. Taking note of a similar interim order passed in WP 8110 of 2021, there would be a stay of annexure E and F.
Yeah.
The respondents are at liberty to file a statement of objections and seek for modification of the order. Now, what are you saying now? What is the change in rainbow?
Statutory authorities have to first help into the shoes of the secretary. They have to take measures for them to get classified as that is, they have to create a charge corporate. Only then their claims can be asked. And if the resolution plan neglects their claim, that resolution plan is violative of festival. That is what rainbow claim.
No, in case of charge by operation of law now, in that they were, he was mentioning in some Gujarat, they were by operation of law, there's a charge. Then what happens to?
Actually, in the rainbow case, what had happened? Statutory department, much before the initiation of the corporate had initiated steps for recovery. Subsequently, during the pendency of the CARP, a charge was ignored by the successful. That is where the question came.
So
Whether
there,
they are a secured creditor and whether they rank in the case of liquidation, what is the ranking at the time of audit?
so a charge must be created.
Yes, only when they come into the step into the shoes of the secured creditor, their claims cannot be ignored.
If they don't participate in the process, then there ends the matter, and they have to reopen the.
Even if they reopen, section 31 is applicable. So it gets extended.
No, but then they can challenge the.
They can challenge in enclave. That they can challenge. If the claims are not accepted, the claims are ignored in the resolution. They have a right to challenge that resolution plan in enclave.
No, but if they have not put forth their claim, then they can seek for reopening of it.
They can't. They can't.
There is no remedy.
There is no remedy. But not against the TD, not against the corporative. erstwhile management of the same. Secondly,
Their personal assets can be added.
It is.
That was also requested for to correct for new file number that are if then not for the assessment year 2019-20 return was filed not on 48/9 as per Article C. It
Yes.
then not what is for the issue that should be not.
No, annexure C is,
Article C is return filed by
yes,
for the assessment year 19.
yes,
Then what notice for issue when section 148 here, alleging that certain transaction not with respect to Karnataka Bank is left out in the assessment history. In that not notice what fund number want to get it in 17.
yes,
This office is in possession of the following information. We have undertaken the following transaction. Financial year 1890, 11th assessment year 1990. The said information shall be that in accordance with the dissemination of certain filer portal selected under the management statute, Central Board of Direct Taxes disseminated assessing officer and this all immediately giving out class 1 of explanation 1 to section 148, which suggests that the income taxable to tax as escaped assessment. Analysis of the information of assessment of officers suggests that the income taxable to tax on account of undisclosed transactions as escaped assessment for the year under consideration. The said transactions are undisclosed as no income tax return for the aforementioned assessment year has been factually incorrect. Hence, as per section 148 AB, you are requested to explain along with the supporting evidences and so cause as to why the notice under section 148 should not be issued as a means of information. Just that income taxable to tax has escaped assessment, the case for the 11th assessment year. Your compliance is requested. Then not I submitted by replacement as our expertise. And we have filed our idea in respect of assessment was already completed.
now can the, just now, can the same notice which you have issued be done with respect to the earlier PAN number? Whether at the present juncture, time would permit you to issue the 148 EB notice to the earlier PAN, whether it's still time is open. If it is so, then we will set aside reserving a liberty for you to issue 144 AB as regards the earlier PAN. No. In the reply, what they say that the notice that you have issued is with respect to a wrong PAN number.
Yes, sir.
Duplicate PAN number. So what I'm asking is whether time would permit, suppose we were to say that the same subject matter of 144 AB, you can issue to the PAN number in which he has filed it.
Problem, that they have raised in respect of other 17. Then I filed requisition to the Honorable Court. The Honorable Court divided the matter, directing them to give an opportunity of hearing and personal hearing also. First, not have to produce record.
Okay, but I am on the point that insofar as this duplicate or extra PAN, whatever proceedings you take, that dichotomy will still remain because he has been filing returns under another PAN number. So suppose we were to set aside everything, reserving liberty, whether the time is available for you, that you find out. Whether suppose we set aside whatever notice was issued to the duplicate PAN, whether the same subject matter notice can be issued to the other PAN. If it is so, then you can do that. We will observe. We'll have it next week. You find out on that point. And so for merits, it's a different matter. But it will perpetually remain that this PAN number is not in existence, to which you have now issued notice. Find out. We'll have it next week.
How again problem that was demanded from the I but you are given to all the records.
No, correct. This notice will have to go if it's against a different PAN number. That let them find. Relist the matter on 6th and 12th. The Lord Counsel Sri Sanmati accepts notice for the respondents. Relist the matter on 12th in the orders list. Yes. Now, why is it come in the preliminary hearing list?
Last day of battle error, we have to go back to the SRT, you know, other plan. That the process
What are the facts?
Assessment is contrary to AY 17 and 18 law. Our order was passed on 31/12/2019, and subsequently I filed an appeal before the CIP on 29/1/2019.
Yes.
Later, my lord, the next day I filed a rectification application under 154. Before that was also filed. Rectification application was but the assessment officer, as could be seen from annexure G, they issue a communication stating that there is an error apparent on the assessment order, and they will consider the assessment order. That was not been issued, and this is also been not been considered by the respondent one. And before this order.
Annexure E page.
Page number 83.
86.
86, my lord, they say, therefore, the rectification order will be passed, making the necessary corrections. And my lord, I have produced the comparative statement. And clearly shows the amount total
Now that rectification order has not been passed.
So no rectification order.
The appeal is still pending.
Appeal is disposed. Appeal is dismissed.
The same ground you raised in the appeal.
But during the pendency of the appeal, this communication was given. This was not considered by the CH-11. And without considering the errors in the assessment order, CH-11 has rejected my appeal. That's my contention. One way the appeal before the issued order before CH-11 becomes infructuous because of the election appeal.
Yes, what you see. Aniksha? Yes.
Last paragraph about the few lines.
No, so there has been some rectification or no?
Rectification
Has been done.
and there is some variation. Certain stages cannot be law. But because this rectification order merges with the assessment order, but that should have been, either the assessing officer or the assessing are invited to attention.
Appellate authority.
But the CAT and the appellate commissioners are not passing an order, whatever is the reason. But inquiry will not be done.
So now, if this order at Annexure E speaks for itself, we'll treat it as 154 order, and then in so far as if he is satisfied with this order, there ends. If otherwise, then liberty must be reserved for him.
CAT is already, there are two ways.
Is a appealable order. But then, correct, but then the appeal against 154 will be very strict. Appeal against 154.
That's why. But when the 154 order was passed, the tendency of the either by partial ground, to have a bearing on the.
No, so then we can restore the appeal.
Restore the appeal. So it is not a very additional cost, but we are not.
Yes.
These figures form the basis for the assessment order. If it is any order will not let them consider fresh. Let them consider the assessment with any figure. I don't mind.
No, they are saying that this order at Annexure E speaks for itself and has made out rectification on some of the items as it is. If that and raise additional grounds. There ends the matter. Then insofar as whatever rectification has been made to your favor, appeal will go. Whatever which remains unaddressed in your 154, you can raise by additional grounds and prosecute the same appeal. No, that we can't enter into that evaluation at this stage. Either the appellate authority will have to see. So this is the only correct.
Actual aspect, whether it is 10 or 11, but it should be
No, so now we will declare Annexure E to be the order of rectification on 154. Appeal will stand restored. We are at liberty to place this as an order under 154 and seek for appropriate amendments in the pending appeal. Yes. Yeah. No, so you have gone through Annexure E, and in the body there have been
3 lines what is
is to be ignored.
because all previous paragraphs, and I made a comparison with the previous. This is a variation announced the decomputation has been.
No, correct, but that let the appellate authority consider. And even with respect to 154, you are at liberty to file appeal and have it clubbed with that appeal. the time, what about the time now? We'll just observe and leave it at that. Because he filed it under the impression that the last 3 lines would result in passing of a fresh order. It's a bona fide mistake during the pendency of these proceedings. No, correct. But here, because now, since a matter is pending before this court, under his impression that the last 3 lines would have resulted in passing a fresh order, we'll exclude that for limitation. Yes.
How
60 days. Yes.
is finding that is that so limitations are there. Have one more application than
Yes, the petitioner has called in question the correctness of the order at annexure A dated 28/3/2023. Annexure A is the
CIT order.
28/3/2023 is null and void and remand matter back to respondent number 2 for reassessment of the return of income for assessment year 2017-18. The relevant facts made out are that an order came to be passed, assessment order came to be passed for the assessment year 2017-18 on 31/12/2019 and aggrieved by such assessment order. The petitioner has filed an appeal before the Commissioner of Income Tax under section 250 of the Income Tax Act. Next, in the meanwhile, it is borne out from records that on 30th of January 2020, application came to be filed under section 154 of the Act seeking for rectification. The said application came to be disposed of as per the order at annexure E dated 24/2/2020 during the pendency of appeal before the first respondent. Next, learned counsel for the petitioner submits that the petitioner was under the impression that the order at annexure E would be followed by an order of rectification in light of the observations made at the end of the order at annexure E, which reads as follows. Therefore, the rectification order will be passed, making the necessary corrections as mentioned above and restricting the section 10 capital AA deduction to 1729/81/487 as detailed above. Next, it is submitted that the Commissioner Appeals has disposed of the appeal without waiting or taking note of the rectification order, as a result of which petitioner is aggrieved by the result of dismissal of appeal, copy of which is produced at annexure E. Heard both sides. It is noticed that though the order at annexure E contemplates issuing of further order, learned counsel appearing for the department submits that a detailed reading of annexure E would show that the order is the order of rectification is the order at Annex E. And the last three lines of the order requires to be ignored, as in substance, rectification has been made to the original order of assessment in the order at Annex E. The said submission requires acceptance. If that were to be so, and the order of rectification at Annex E having been passed on 24/2/2020, the first respondent who was considering the appeal, he was required to take note of such rectification order under 154 in the appeal pending before the first respondent in appeal number 5/1165/2019-20. Accordingly, in light of the facts as noticed above, the order at Annex A is set aside, appeal is restored to file, the petitioner is at liberty to place the order at Annex E before the appellate authority, which is to take note of it appropriately. Full stop. The liberty is reserved to the petitioner to challenge Annex E by filing an appeal if the same is filed within a period of 2 weeks from today. The authorities would not consider any objection as regards limitation if appeal is filed as against Annex E within 2 weeks of receipt of certified copy of this order. Insofar as the proceedings before the CIT appeals on placing of order at Annex E before the appellate authority, the petitioner is at liberty to raise further grounds. Accordingly, petition is disposed of. 4 weeks. No, but now section 14 of limitation I could apply. Suppose bona fidely they are prosecuting proceedings. Now here, by virtue of the last. Yes, yes.
In the appeal period,
Yes. Yes.
attaching three of my bank account. Same payment by yesterday. Near period is over.
This is 83, is it? Next page.
In the meantime, I also filed an affidavit report. Whatever the amount I will receive to the party, first I will deposit to the concerned authority. Thereafter, it will be.
Page.
Page 50. $83.
This is dated.
Not dated 21/6/2022. Simply arranged by yesterday.
Yeah. Huh? Yes. The
I also filed an affidavit to the effect. Whatever the amount I am going to receive first, accept.
yes. The petitioner has called in question the validity of the order at annexure Q whereby the respondent authorities had passed an order of provisional attachment under section 83. The order itself stipulates that the attachment would be enforced till 21/6/22. Next, in light of lapse of 1 year in terms of section 83, the attachment would cease to have effect on the expiry of 1 year, that is, after 21/6/23. Accordingly, the writ petition does not call for any adjudication while declaring that the attachment has spent itself. The counsel for the petitioner has filed an affidavit containing certain undertakings. Same is to be taken note of by the authorities. Accordingly, petition is disposed of. Yes. 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 This is an order under 73(9).
It's 10, para number 10.
Para
10, madam.
at page 12. Yes.
Para number 10.
Yes.
Issue that madam in this case. The way to file the GST return of March 2019, the due date of April 2019. Because of the RC was cancelled. RC was cancelled in the month of December 2018. And immediately thereafter, annexure D is number 50. RC was cancelled 27. And immediately thereafter, on 27th February 2019, filed an application for revocation. And revocation was again, revocation order was passed in 13 March 2020, after a lapse of 1 year. In 13 March 2020, when revocation was cancelled,
13th?
thereafter, on 17 March 2020, he has uploaded DSCR degree.
Just it was revoked on 13th
13 March 2021.
annexure.
Annexure C, page number 7.
Yes.
Immediately thereafter, assessing was filed GSTR 3B return for the month of March 2019 and 17 March 2020.
Yes.
This is the issue, madam. Now, since the 16.4 is there, 16/4 is the rider is there, which says that madam, if we don't file the GSTR 3B return for September, that time it was September 2019. The year end is 2019, March 2019, any return, any correction is to be done by September 2019 and was there. So he did not file it, because impossible, practically impossible, because his RC was cancelled. RC was cancellation was revoked only in the year March 2020. Immediately on the same month, in gap of 3 days, he has filed the GSTR 3B return 17 March 2020. All these details could be placed before the assessing authority. But unfortunately, madam, since this case was taken up for scrutiny, the scrutiny has been taken up, and all notices was issued through digital email ID. Now, when we issued DRC-01, madam, after issuing DRC-01, nothing but a summary SOCAS notice. After issuing summary SOCAS notice, the order was kept to be passed on annexure E, madam. As per annexure A,
He has not provided opportunity of being heard, my lord.
Opportunity of?
Being heard, my lord.
No.
You read entire order, my lord.
Now, annexure A is what proceedings?
Annexure A, 73 subclause 9, my lord, he is marked in order, my lord.
Now, this material you are not able to place before him.
Yes, sir.
Para 10.
Para 10, my lord.
Just read.
I read it, my lord. By issuing ASLP 10, ASLP 10 comes because of the scrutiny of return. See what the CPS Act says, we can take up the scrutiny. Scrutiny has been taken up and they have identified the discrepancy. Yes, you have not filed the March 2009 return. Since you have not filed March 2009 return, but you have filed it in April 2020. They find out that yes, this is the lacuna is there, this is 2064, this is inapplicability. You cannot claim in the ITCR. So because of that, my lord, they should DRC 01A. That is the intimation, sir.
Yes, what do you say?
Yes, I have to.
Reason for cancellation is also not attributable to you. Yes. No, so now what? So what is to be done? Yes. Yes. No, my screen is different. My screen is different. Yes. Finally, this delay may be condoned, isn't it? This GST 3B. Now, in case of such eventuality, wherein his registration was cancelled and revoked, then what happens?
Here actually, my lord, the revocation application was not appearing in the dashboard. That is the reason, madam. Because of that reason, it took 1 year, madam. I could place an additional exemption.
But now, why can't you file an appeal against this? Including the point as regards delay in considering the revocation application. Also, we'll observe is a matter that is to be looked into. Now, what is the time limit? Excluded. So when was the writ petition filed?
Right on 21st April, madam.
21st April,
2023, madam.
date of the order?
Date of the order, my lord. 21, 2022.
So even then there's delay. Huh? No, the order is passed on 21st of January, December,
21st December 2022, madam.
21st December 2022. Oh, so then we can fix a time because it's within that time. 21/4/23, the writ petition is filed, isn't it? Power to condone is there. No. When Vikram says you must hear, Vikram says you have to give 10 days. Now, what is the position now? We routinely pass orders saying if it's done 10 days, it's filed within 10 days can be. What is the legal position? No, so whether margin is maybe 30 days, 1 month, maybe we can extend the discretion there and say by virtue of Article 14 of Limitation Act, time spent here. Even after that, there is it shoots by another 30 days. We provide some direction in the. We'll say, huh? And then we declare it's not a precedent. And then we declare it's not to be construed as a precedent. So then we'll remit you to the appellate authority. You file it within 30 days. The petitioner has Anjana. Oh. Petitioner has sought for issuance of writ of certiorari to set aside the impugned order dated 21/12/2022, passed under Section 73, subclause 9 of the KGST Act, read with Section 6 of the CGST Act 2017 and Section 50 of the CGST Act/SGST Act 2017, passed by the third respondent. Learned counsel for the petitioner has raised various contentions to the effect that he could not file GST 3B, GSTR 3B, 3 capital B returns for the period of March of, as his registration was cancelled and subsequently revoked only on 13/3/2020. It is submitted that soon thereafter, GSTR 3B was filed on 17/3/2020 for the aforesaid period, but was not taken into consideration. Next. In light of Section 16(4) of the CGST Act. Next. After hearing for the matter for some time, it is noted in light of the contention raised that there was delay in considering the revocation application, as a result of which soon after revocation of cancellation of registration, GSTR 3B was filed on 17/3/2020, and as such aspect is requires factual appreciation. The petitioner is at liberty to challenge the order at Annexure A within a period of 30 days from receipt of certified copy of this order. Needless to state, as a full stop. This order is passed, taking note of the time spent before this court and also the facts of this case, where the petitioner states that the question of filing returns within time did not arise till the revocation of cancellation of his registration. If appeal is filed within the time described above, question of limitation would not be raised. Order is passed in the peculiar facts of the case and is not to be treated as a precedent. All contentions are kept open. Yes. At a request, this is the matter week after next. Interim order earlier granted is extended till the next. Office to show the name of Learned Counsel Madanand Pillai for respondent number 1. You came up with that the order layer Yes. 12th. $132. Yes. You're reading section? Yes, application of seized.
Seized or
Yes.
seized under 152 or offended under section 152A, will be dealt with in the common manner. Under this act, the Wealth Tax Act, Excise Act, the Interest Act, and the amount of liability determined on company under section 152A, and the assessment
So there must be quantification of liability.
existing liability.
Yes.
Who, my lords, or because the Gujarat High Court has interpreted this word and as or my lords, upon completion of an assessment, there would be a determined liability. Now, my lords may kindly skip the remaining portion, the first provision. Provided that where the person concerned makes an application to the assessing officer within 30 days from the end of the month in which the assessment was seen, the release of the asset and nature of source of acquisition and any is explained to the satisfaction of the amount of any existing liability. Again, one thing, liability referred to in this clause may be recovered out of such asset and the remaining portion, if any, of the asset be released with the prior approval of the principal chief commissioner so and so. Now, my lord, the second provision which I place reliance on, provided further that such asset or any portion thereof as is referred to the first provision shall be released within a period of 120 days from the date on which the last of the authorization was reserved under 152 or acquisition under 132 as it is. Now, my lord, the last revenue was that we have time in December 2024 retain this money because that is when the period as contemplated of 18 months will come to an end. Because the seizure of the money happened on 3rd December 2022. My lord, even when the seizure happened from my employee, there was no existing liability for was sufficient. Second company, my lord, for that particular assessment year, time to file my return had also not lapsed. But this is not even something where the question where I have not understood. This is not even understood income. But my lord, the second provision was very clear. Mandate that upon 120 days coming to the name, there has to be automatic release. But this may not have been considered by the Delhi High Court.
We'll continue up to
Yes, no registration for the petitioner, portion of 22/7.
The Lordship's kind permission.
Yes,
May I mention a matter with your kind permission?
yes.
I'm appearing in item number 38 and 39, but I was told by that the final hearing matter posted at 2:30 will go on, is likely to go on for the rest of the day.
Yes.
May I request that this can be taken tomorrow, though it's a tax matter, because the last date for the compliance is coming next week. So if 38 and 39 can be taken tomorrow as part of the admission board.
Now you serve advance copies.
Ah.
Just 1 minute. We'll have it tomorrow, but you serve copies on 30th.
On the department.
Just wait.
Sorry, I'll wait. And 39.
Deputy Commissioner of Commercial Taxes. M. Kumar takes it. DG M. Kumar is directed to accept notice. Release the matter in the same stage tomorrow. Next matter also same.
Yes, bro.
Yes. You serve it on the government advocate M. Kumar advance copy. We'll have it tomorrow.
Yes, obliged.
My lords, may I mention 42 again?
38 same. 38 same. 38, 39 same.
Item 41.
Just 1 minute, counsel. Just 1 minute. Yes. One extra copy. Extra copy. Serve an extra copy on him. On him, Kumar. Yes.
My lords, I'm seeking indulgence with respect to 42 again. That came
Yes.
up, for which the department was seeking adjournment. If my lords want to take it up before the, it's only going to take 5 minutes. I'll just explain quickly and then we can fix up a date as per the.
So just wait. Before I take up the final hearing part of matter, I will take it up. Just wait.
Much obliged.
Yes, your instructions are complete, is it, in this matter? 27. Now, who's the answering respondent? Him, Kumar, you are the answering respondent or? Huh? The instructions, Arvind.
It's all from the back. The persons who are carrying the cash, but as before, they did the inquiry. And this person, this comes not and makes it time. Those persons are inquiry. These are all the inquiries and the return portal.
No, okay, no. I mean, I just want to know, but what is the purpose for retaining it? Now, suppose your he has filed his return and he has declared it. Now, can it not be that you obtain some indemnity and release?
Otherwise, you must really appreciate. If somebody's cash up in somebody's name, that person is not relaxed or somebody cannot be implemented.
Now, it has been seized from X. Now, the X is not before the court.
My employee, my lord, X was driving my car.
Okay, you join him in the petition. Let us see what stand the department will take. You join him in the petition. What is the alternative?
Let me take something of what my learning can be saying.
No, we'll see. Now, if your instructions are complete, I'll fix a date because today I have a part of.
Very well, my lord, because I'm covered. I even shared the judgment, I think he should get another part or what I said, it might be by department can't hold it on like that. They have to at least start on that. But in fact, in one case, Delhi High Court, similarly, when the matter was seized, when a requisition was filed in the High Court, then they went and passed an order saying that this money is for some liability. But even the High Court in that state said that it's not purposeful.
Now, finally, whatever it is, As long as your investigation is complete, now some process will be on. Once you complete the investigation, then under law you give it to them with whatever indemnity. I don't know what the procedure is. You can complete an investigation, but unless you say that suppose it is involved in A, B, C, D, you have the right to forfeit. Then that's a different matter.
Only the weekend knowledge is there. But what a tax liability arises.
Why don't you impede your employee for have it? Let us see. Suppose that would make a difference. We'll see.
Representation had to be considered by now, we have not considered it.
Now you consider it in the meanwhile. Let us.
ನಮಸ್ಕಾರ
The alternative prayer.
ಇವತ್ತು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಅದಲ್ರಿ ಅದು
That will consider. This the matter. This the matter on 6th, on in the same stage. Next, only one. No, we have only Wednesday as a working day, so it list is full. You take a chance on 6th. The list is full. List is full. Open for the authorities to consider the alternative prayer regarding consideration of the representation dated 6/2/2023.
But this is also been open, that this is without consideration. So my right that it cannot consider.
No, they're only considering it. Needless to state, such consideration will be taken note of appropriately by this court. Yes, next. This is the matter on 12th. Yes.
No, right. Item 28, my lord, I'm appearing for the counsel for the petitioner, counsel on record.
28, they served copies only today. So they've taken an adjournment.
Yes.
Copies were
Much.
For the petition in this matter. Unlucky, which time that what because for disposal because the procedure was followed was not 148A, followed under 148. So
we list the matter tomorrow. Yes. Yes, M. Kumar, what? Instructions are completing. Take some time, then we'll have some other day. Now, what is the contention raised?
The vehicle was not. 2006. The year 2006, by the application for the exam. But what has happened? He has not paid tax of 2011. The authority filed a civil case before the magistrate and recovered the tax. That is, you are not.
No, correct. Now, the only question is whether the court has the power to waive that deposit. Any authority in the.
It has to be the direction, then only it can deposit. Section 80B.
Then if he's ready to deposit now, we can.
It is having a discretionary power. Because the authority knows I have not been the vehicle since 2006. They have earlier occasion for 6 years. So vehicle has been used, they have collected the tax. Under civil case.
Correct. So now we'll ask the we'll record your submission and then we'll ask the.
Every document is furnished for the appellate authority.
So we'll ask it to.
My only request, there was a direction to initiate DCT in the year 2016. That is annexure M.
No, which is the section? Section. Yes. Yes. Yes.
Please, very.
No, what all the provisor can also be interpreted. It is provided that the appeal authority may its discretion. So it could be either suo moto or otherwise. So we could say that. Now just tell me, correct. Now just tell me, this proviso applies to 1 and 2 to the whole provision or only to 2B? So that is. So insofar as 2B, he has a discretion. So now what? No. Now what we can do? We can dispose it off. with the observation. Under 2A, you have paid that, isn't it? Insofar as 2B is concerned, we'll record that you, according to you, you have bona fide reasons for getting the benefit and the proviso. And you are at liberty to ask the authority to exercise the discretion under the proviso by appropriate application and will dispose it.
That memo also I have published, connection to this. That is memo filed before the appellate attack. That is my request also.
Page?
That is connection, page 54. The detailed memo has been filed before the appellate attack.
Asking the court to waive that 2B.
And my request, you may kindly produce connection C, page 30. Page 30.
Just 1 minute. What is this 31/12/2022? What is the order of 31/12/2022?
This is the connection M. What's question?
That is the order of dismissal.
Notice.
No, correct. Now, I'll give you liberty to file an application before the authority in terms of the proviso to, and then let the court.
One suspicion.
Yes.
Because here for the reason connection C may kindly.
So that now you go there now.
I will agree with you that direction of his honorable, but he never used the vehicle since 2006. What has happened? We have bought the vehicle as per the surrender form 30. But after 5 years, the vehicle has been stolen. He has given a complaint to the authority, but he has not filed any complaint before the police. FIR he was not registered.
Yes.
And connection F may kindly be produced.
So let us see. That's on merits. I'll observe it and fix a time limit. Petitioner has filed the present writ petition. Seeking for setting aside of the order passed by the respondent number 1 authority dated 6/5/2023 in appeal 1 of 2023 at annexure M, whereby the appeal has been dismissed in light of provision under 15(2)(b) deposits not having been complied with. Next, the limited facts for the purpose of disposal of the petition is that the petitioner had filed an appeal the petitioner was the owner of vehicle KA099192 with respect to which RTO had granted permit. It is further noticed that there were certain recovery proceedings. The petitioner I filed an appeal. Which, however, came to be rejected on the ground of non-compliance of 15(1)(b). Next, section 15 reads as follows. Next, 15 of the Karnataka Motor Vehicles Taxation Act. It is not in dispute. Motor Vehicles Taxation Act 1957. It is not in dispute that the deposit in terms of 15(2)(a) has been paid. However, it is submitted that the appeal has been dismissed, taking note of 15(2)(b). Counsel for the petitioner has narrated in detail and in the present petition averments which, according to him, entitles benefit of extending the discretion under the proviso to 15(2)(b). Next, it is noticed that the authority has rejected the appeal on the ground of non-compliance of deposit under 15(2)(b). Next, must be noted that the proviso under 15(2)(b) confers upon the appellate authority, which may, in its discretion, give directions in regard to payment of tax or other amount, and may also accept security furnished by the applicant to its satisfaction. Next, must be noted that while exercising power of dismissal, the authority ought to have the authority is entitled to exercise discretion in terms of the proviso for passing such order of dismissal. Taking note of the submissions made by counsel for the petitioner, it would be an appropriate case for setting aside the impugned order of dismissal and remanding the matter back for the appellate authority to exercise its discretion conferred upon it under the proviso to 15(2)(b). The petitioner is at liberty to file additional pleadings seeking invocation of the discretionary jurisdiction under the proviso to 15(2)(b). If the petitioner files such pleadings within a period of 1 week from today, within 1 week from today, the 1 week from date of receipt of certified copy, the authority may consider the same expeditiously within a week.
4 weeks, madam.
Expeditiously.
Otherwise,
Expeditious.
will appear before that. It's a single case.
No, so now as soon as you get a certified copy, you move it.
Yes, then not.
Yes. Next. How much shall we?
4 weeks. Last occasion when up to very rare.
Orders to be passed on the appeal itself. On the application for in terms of the proviso to 15(2)(b) within a period not later than 6 weeks. Yes, next, please.
Case, there is a continuously snapped by the authority in the COVID period, not filing the record. Therefore, the cancellation of the registration. Next at which we are going to challenge before the Honorable Court can restore the
Who will accept notice for G? Counsel. You just look if the Description of the second respondent is sufficient. No. Now I'll just order for notice. But is the description of the second respondent correct or something requires to be? That is sufficient. That now both you'll accept or Third Council G1 accepts notice for the respondents. This is the matter week after next. Office objections to be complied with in the interregnum. Next.
Lordship, serial number 32 appearing for the petitioner.
Yes.
We may be permitted to comply with the office objections, my lords.
Week's time granted for necessary compliance. Next.
Short submission, my lords.
Yes.
The petitioner filed 2 writ petitions actually. The another one came before this court on 15th of June in writ petition number 8321 of 23. Writ petition number 8321 of 23 for the earlier financial year.
Yes.
And interim order was granted, my lords. We request that this a similar order may be passed in this matter also. Writ petition number 8321 of 2023. Order dated 15th of June 2023.
In that matter, who appeared in that matter?
My office appeared, my lords.
No.
Respondent,
Respondents.
Mr. Hemkumar.
Same order. AGA and AGA Hemkumar is directed to us. Accept notice for the respondent. Submitted that time. In the case of the same SSC.
Same SSC, my lords. For the earlier financial year 17-18. This is for the 18-19. That was for the financial year 17-18.
For the previous assessment year, in an identical factual matrix, interim order has been passed in WP 8321 of 2020.
Please, my lords.
Accordingly, taking out of interim order passed in above mentioned matter, recovery pursuant to the include notice at annexure F. The state subject to petitioner depositing 10% of the tax as demanded within a period of 4 weeks from today.
Deeply obliged, my lords.
One of 23. Has been filed seeking to recall order of dismissal, accepting the cause shown. Order dated 12/6/2023 is recalled. Petition is restored to file.
Deeply obliged, my lords.
Can everyone? Yes. Yes.
Verification of the manual filed by the taxpayer. Because the notice of the taxpayer has been made of do not have worked on a CGST and that one. The breakup for the credits available in manual amount of salary carried forward to electronic credit ledger, 133 crores. Sir, what is there in the return that comes from the bank? Amount of unavailed capital credit carried forward to electronic credit ledger. Amount of eligible duties and taxes paid in respect of input or input services under section 145(7). We have observed with this.
Yes.
The allegation made the show cause was that the Lordship, see the next paragraph. If the subsequent bills was noted an amount of this one has been debited from electronic ledger, the balance credit availed has also been verified in the audit team and found that credit availed on eligible taxes paid in respect of service under 145 is one. So it is noticed that the said credit is also reversed on 2018 by distributing these credits under invoices to various locations. The taxpayers have taken credits pertaining to Bangalore premises duty, but it appears that an amount of 70 pertaining to resident persons from other states with the same bank has also been taken and transferred to CH-11 credit. However, the said credit is reversed on funds. As the credit of regular interest liability arises, interest liability for this in the case of Lordship that was set up in the show cause was, there is an amount of 70 crores under 145 which we have got. This we have distributed to various places. That means entire 140, the 72 crores doesn't belong to you, belongs to the other states. Therefore, having distributed it at a later date, you should pay the interest for the period when you retain it here. That your Lordship was the case. And 145 your Lordship situation where what happened, my lords, 170,017 your Lordship is given to pay. Now there could be situations where taxes are paid under earlier regime, service tax or excise. So you receive the invoices, the subsequent are not receiving exactly what this is. So that's what they made a provision. And in respect of those cases where tax earlier regime, you receive invoices for it within a period of 30 days, extended to another 30 days. 60 days time limit was there. After tax is paid in the earlier regime. This was the service tax paid in the earlier regime. So the show cause notice in the exact record, they took an impression that 72 crores relates to other places and therefore we should not have retained it. We point out to the authority that your understanding is wrong. This 72 crores continues to remain here only. What they have cross charged is completely a different set of amounts. This amount has not been discharged, has not been transferred. This your Lordship, the order original, the authority your Lordship, kindly have a look at page 160.
Yes.
There are 14.
Yes.
The notice has also presumed the credit of rupees so and so has been reversed for the notice of 2018 by distributing the credit under invoices to various locations. While this allegation of distribution of credit to various locations is actually wrong, as under such invoices, GST was paid utilizing the credit balance available for supplying services. It is not a case of distribution of credit to various locations. So this is the understanding is not. 74 was not distributed. In the order, your Lordship, the authority examines this and accepts your Lordship my submission. Your Lordship, can I have a look at that? There are 28 here, page 167.
Yes.
Further, the show cause has alleged that the notice had reversed the credit of so and so by way of said credit to their office. Whereas the notice had disputed the said allegation and stated that their rate cross-charge invoices for supply of service to the economic because they haven't reversed any credit available under section 145. I find it true in the contention of the notice has submitted cross-charge working for the year 17-18 along with all the relevant invoices wherein the value of taxable service was 1541 crores and IGST GST amount 77 crore. The said invoices were raised for the supply of management consulting services. The Bangalore head office has supplied out services to the office of such activity supply. Therefore, I find assess OTC has not reversed the credit of rupees 1. So, as alleged. Since this credit amount of rupees was not passed, now comes the flip. What they now say that you are not entitled for the 72 crores at all. This your Honor, my lord will see at paragraph 27. They now set up a new case in the order movement. Paragraph 27 on the top. I find that the notice are registered under GST law, but I have not provided any evidence to prove that they have actually received the input services and also failed to provide documents that the invoice or duty or tax claim documents were actually recorded with some amount which is prescribed here. As the notice has not satisfied the condition, I hold that the credit award.
No, this is contrary to the case made out in the show cause.
First one. After this, what happened, Your Honor, when I filed my appeal, I also kindly have a look at page 180.
No, just 1 minute. Now, we'll consider the interim prayer and then we'll see. Let them file their objections.
There's only one more point. Just one more. In page 184, Your Honor, I appeal to the first appellate authority. I gave a complete reference of the evidence for receipt of invoices accounting for it within the period that was stipulated. Next, my lords will see at page 184, para 1.
This is in which, in what context you furnish?
So, we raised a case in order 72 crores are not eligible for the tax credit because they have not provided evidence to show that they have received the invoices, they have received the input services, they have accounted with the chief to the effect tax.
So that explanation you gave by an extra.
The appellate authority, after noting your answer that I given all these documents, does not give a finding on why these documents are not relevant, and therefore you have to confirm the order. Two submissions for that. One, the order and the orders proceeds on a basis different from the cost. Two, even after I give all the evidences, the order and appeal does not recognize those evidences and still confirms it. And more important, your Lordship, also kindly see the show cause notice, your Lordship, is issued under section 7 of this Act. The entire 72 crores is a transitional credit. That is a credit for the tax paid under the earlier. When 73 refers to input tax credit, that is defined under the GST Act, input tax credit under the GST Act. So we have a CGST, SGST, all that are considered as an input tax. Now 73 of the GST Act can be applied only in respect of input tax credit under the Act. As far as this is concerned, tax paid under the earlier Act, not eligible taxes under the earlier Act. For that, they have saved the provisions of the earlier Act. That's so once you have to take action in respect of the earlier taxes of the earlier Act. You can't invoke section 73 for questioning the transitional credit. That's more fundamental as far as the provision comes.
Okay, but this is a matter that requires. correct, on the second contention, that pursuant to during the process of hearing, Annexure M reply has been made out. Let us see now on the second aspect. Consider the interim prayer and file your objection. The contention. Current senior counsel appearing for the petitioners that in the appeal proceedings, clarification has been made by submission at Annexure M relating to the input services amounting to 72 crore 98 lakhs 81,641. And such details furnished was not taken note of while passing the impugned order. Subject to further consideration, there would be stay of Annexure A. Respondent at liberty to file the statement of objection and seek for modification of the interim prayer. Yes, next.
The old law, 4 years.
That is 147.
Regular certain additions from it, other issues. Thereafter, another notification under the provided 147. Let's say the India one will come in the accepted receive time bar for the 19th. Then it could have been extended, but until voting. After that, provided to 149 1 provided something to not have been done, then it cannot be done under the new. Simply put, it cannot be done under the new provision. On that point alone, because it was signed out on 21st of March 2009, something which was signed out as on that, it cannot come back to the absence of the series. That's why the morning also submitted number 17 and 18. The same point. Apart from that, I have points on the fact that how on benefits.
So now, in terms of the proviso to 147.
The old term. There should have been a failure on my part. There should be an allegation first of all that there was a failure on my part.
There is no such.
Not in so many words. He says that looked at the assessment records, but it appears you're not giving a valuation.
Now this is a requisite for going beyond the time of 4 years, isn't it?
The requisite is that there should be an allegation that there was a failure on my part.
The counsel for the petitioner submits the notice is at annexure.
What is that?
That is pursuant. Page. Counsel for this petitioner submits that the notice under 148. So this is the new provision, isn't it?
The time between 1st April and 30th May of 2020. the notices need to be issued. Following the procedure under the old law, those notices need to be challenged for some number and other items, and ultimately.
So they said that those notices will be treated as one part.
Information.
Counsel for the petitioner will submit that the notice issued under the original unamended 147. If 140, 148 would require a jurisdictional finding that there has been a disclosure fully and truly of all material facts. There should be a failure to disclose fully and truly all material facts. And in the absence of such jurisdictional finding, the notice at annexure B2 itself being faulty, subsequent proceedings are liable to be set aside. Subject to further consideration, there would be an interim order of stay of A1 to A3. Respondents are at liberty for modification of interim order upon filing statement of objections.
36. Number 36.
Anirudh. Serial number 36. You're not audible. Please unmute yourself. I'll pass it over. I'll take it up. I'll pass it over. I'll pass it over. I'll take it up. Next. Yes. 2000?
1570.
Yes.
The case about where notice was not an old problem. Thereafter, Rajesh Agarwal came and it helps to solve another problem. Of course, our first contention remains that 60-70 4 years avalanche when the 31st March 61. Therefore, the time period, because Rajesh Agarwal, if you must recall, says that contention as regards limitation under 149 will be kept over.
Yes, income tax. Council Dilip accepts notice for the respondent. You want to go through it?
This case covered where also regular assessment is done. You kindly see the information that they have.
Give him a copy.
Page, annexure N, page 626.
Give him a copy if you have extra.
Yes. Annexure N, page 626.
Yes.
I'm sorry. I'm sorry.
Page 626.
Yes.
This is the information at page 67, the second paragraph. On examination of the information, you notice that the assessor has received stamp and shown fictitious losses in stamp transactions derivative amount. So, relevant to AY 1670, as the assessor has made fictitious short-term capital loss of and therefore SC has understated his income. This is the information that they have. Now, kindly see, my lord, what happened in the regular assessment. My lord, kindly turn to Annexure 8, page 86.
Let us see, let him take some preliminary instruction, we'll consider it on witness.
The counsel, in case of change of opinion, because a limited scrutiny assessment was done only to examine my claim for capital loss.
Where do you find that?
Annexure 8, page 36.
This is in the regular scrutiny.
Regular assessment proceedings, limited scrutiny only on this point, whether my claim for capital loss is correct or not. Annexure 8, page 36, my lord, sir.
Yes.
Kindly see, there is a notice under 143(2), assessment year 16-17, way back in 2017. And kindly see, following issues identified for examination, whether capital gains loss is genuine or has been correctly shown in the return of income. I filed detailed submissions, proceedings went on for 2 years, and kindly see the assessment order accepting my Annexure F, page 546. After submitting all the documents, examining the issue of my claim for capital loss in detail, assessment order, Annexure F, page 546, assessment passed, accepting my return. No addition at all. Page 546, Annexure F. All the transactions of my shares, I claim for capital gains, capital loss, everything examined thoroughly, and it's a case of limited scrutiny, not just regular scrutiny where all issues are examined. Limited scrutiny on this point only.
Stay your file. Now, Junior Counsel appearing for the petitioners submits that now which is the impugned notice?
What this word is, in fact, assessment order is called. Assessment order is Annexure Y, page 761.
Now the reassessment,
Order, that's right, reassessment.
it's only on this aspect.
Only on this aspect.
Page?
Annexure Y, page 761.
The assessment order at Y pursuant to reassessment proceedings have adjudicated as regards to the aspect which was a part of limited scrutiny assessment. As per the proceeding at Annexure A, it is further submitted. Where is that aspect? You said that question of what was framed at page 36.
Its first all the issues have been identified for examination.
It is further submitted that the question whether capital gain / loss is genuine and has been correctly shown in the return of income was considered and explanation accepted while passing of the assessment order. And at this point of time, matter could not have been reopened in the name of reassessment proceedings, as it would amount to a change of opinion. Subject to further proceedings, there would be stay of.
That is a demand notice, not sudden. And the penalty proceedings, annexure A, page 780.
Demand notice at Z and
Penalty proceedings.
and
The penalty notice.
penalty notice at annexure
A.
AA. Respondents have the liberty to file a statement of objection and seek modification of the order.
Wait, please, my lords. I'm sorry. My lords, serial number 36, there was some problem, my lords, with the audio. I'm really sorry.
Just 1 minute. Pause this.
Grateful, my lords. My lords, this case, the demands have been confirmed on the basis of financials filed under the Income Tax Act, now which my lords have been seized off, and in terms of the Madras High Court decision and batch matters which are listed yesterday, my lords, that serial number 54, there has been stay. Now the challenge here is to annexure F and J, which my lords would find at page number 48 and 70.
Just 1 minute. Just 1 minute.
Yes,
Just 1 minute.
yes.
The central tax. Madaran Pillai accepts notice for the first respondent who G1, is it?
G1.
Huh? 9,000 G1. Right to accept notice for respondent 2, 3 and 4. No, he's not there, so if you have to consider something, we'll have it on some other day. Let him, in his presence, we'll see what can be done.
My lords, I'll demonstrate to my lords that it is based on 26 years. The orders say so in as many words. I'm just requesting for a stay of annexure F and J, and let the matters be tagged on with the matters which are listed on 6-7, my lords.
Now, which is the interim order, the past in other matters?
Interim order passed is in writ petition 1154 of 23. No, I have not enclosed it. It was listed yesterday, my lord. Serial number 54, all the batch matters.
Yes, council. Yesterday's matters files have gone.
I'm sorry. But
WP?
Firm Foundation Housing, Madras High Court. Pardon, sorry, my lord.
Writ petition number
1154.
So the same interim order.
Same interim order, man.
Non-counsel for the petitioner submits that interim order has been passed in other petitions where the same legal question as has arisen in the present matter has been raised. Attention is drawn to the order passed in WP 15959 of 2021, which reads as follows. Next, accordingly, in light of the same, there will be an interim order of stay of operation of
annexure F and J.
F and
J.
F and J. List along with WP zones.
Deeply obliged.
What is hearing?
Appearing for the petition in this matter, my lords.
Yes.
My lords, this is a writ petition filed challenging the order passed in annexure K at page 97 under section 1192B of the Income Tax Act. An application was made by lords by me before the Commissioner of Income Tax seeking a condonation of delay in filing the IT return. Because as a result of that delay in the assessment proceedings, even though everything that I have filed in my income tax return has been found to be correct, but the deduction claimed by me under section 80P has been denied because the condition under section 80AC of the Income Tax Act has not been complied. Therefore,
this
it is
income tax. Non-counsel should believe accepts notice for the respondents.
Please, my lords. I'm a primary agricultural cooperative society, and making
we'll have it next week. Let him get here. Preliminary instruction will come.
Please, my lords.
List the matter in the orders list 28.
Deeply obliged, my lords. My lords,
41.
The stay of A1 and A2. Same order. As it is. Same. Office objection is overruled subject to the undertaking that the legible copy will be produced if so required. Then council should give G1 accepts notice for respondents 1 and 2. Right? 230.
Number 42. Aditya Vikrambat. 42.
My lords, I am appearing in 42 for the petitioner. The only submission that I had, my lords, with respect to the adjournment request of the respondent was if my lords can just have the last order, 18 July 2019 order, the order along with my early listing application.
IA 1 of 21.
That's right, my lords. Annexure 2 of that order is a scanned copy of the certified copy of 18/7/2019 order.
At page?
My lords, it's annexure 2, page number, if my lords can turn to page number 36 directly of that application.
Yes.
My lords have it?
Yes.
My lords, the order was heard the learned counsel appearing for the parties. This court is of a considered opinion that the issue involved in this writ petition requires to be considered subsequent to the decision to be rendered by the full bench in WA number 1145 of 2015. Now, my lords, this decision has come. What this decision says is that where there is a completed assessment under 143(3) and the party had made a full disclosure, there was a query raised by the assessing officer which was answered and it was considered during the assessment. Then after 4 years having been lapsed, the assessing officer cannot make an addition on the same issue. And in my case, my lords, they had actually made an addition in 143(3) under section 10A with respect to the claim that I had made. And now when they are seeking to reopen this particular matter, they have actually said that from the records, we feel that this is an issue that has been not considered. Therefore, we want to reconsider the 10A deduction issue. So, my lords, on these very facts, I already have a stay in this matter, which is absolute in terms of this order itself. All I'm asking is that this matter can actually be disposed of whenever, as per the convenience of the honorable bench. But this matter can be taken up in the earlier list, probably a preliminary hearing list or in the admission list, so that this matter be taken up and disposed of accordingly. It's covered by the decision of the full bench of this honorable court in Dell International. That's the only submission I wanted to make.
This is the matter in the orders list on.
My lord, 6 July, 2 weeks is.
We'll have it on 12th.
Very grateful, my lord.
One matter what is the lawsuit secretary is not out of. What are the
They say it's covered. We'll make some arrangement. Maybe on one of the days, we will go at, we will directly take up before orders, we'll take up final vote.
There is not a case of another 1 minute.
Let us list the matter on 12th.
Much obliged.
Hmm. Oh,
Yeah.
amendment. IA 1 of 23 is allowed as it seeks to call in question correctness of orders passed during the pendency of the present writ petition. Necessary amendment to be carried out. Objections, if any, objections to be filed to the governments. Correct. Objections to be filed to the governments permitted to be inserted by way of amendment. Amended petition to be filed within 1 week. Let us see. 28th, too many matters. We'll have it on 6th. 6. Okay. Disposed. Okay. This time I in the orders list tomorrow. Yes. Yes. Available.
Soft copy.
Yes.
Number 1, 2, 3, and 4. How I propose to take number 5.
Yes.
Page number 136. The entire outcome is which it is contemplated. How should we see how the most has been prepared in relation to this ground level? What can we take to second para after that? Medical one two.
Just repeat, what is this 0.5? 5 is a,
Especially at the end of the day, they may not reach system is independent. So like, they make a document and they get information pertaining to that. They open so any semblance of a material. How it is proceeded? What I want to indicate. That aspect I done before, but I'm something. Yes. 132 was carried out on 21/12. Whatever. Based on the findings in the course of transaction and the details submitted in the course of assessment for assessment year 1890. So the whole idea issue there is a finding. But such action never has been taken. Such in terms of something to the act is assessment. Such is something. Is it? Such C is required. And then the other cases. There is a report which they make in the search will and the assessment. The legal record and what is the finding is not known to me. I'm having a finding. What finding it is not in my domain at all. The court, the details submitted in the course of the assessment for the 1890. Model for 1890 and refer to page 47 of 79. In this particular. Course section the 132 of the income tax. Backup of email from so was seen by the during analysis of said backup email dated 31st March 2017 on the date. Our 31st June 2016. We cannot presume in law, presume that they have some doubt in that will be extended that year. Because of that, they cannot open 15, 14, 13, and endless days in the from the time the company alternated it. During the settlement, some tangible material for them to come to a conclusion that there is some amount of income escaping us. So my major point, my lord, is for the include order of 148, there is no whisper in the main document that page 136. Whatever information they have provided till today, the other side has not filed paper objections. Whatever they provided is only this particular order. Order which I am not discussing, order with the past what is happening in it. Only thing is nothing related to this. So according to me, my lord, such does not throw anything pertaining to this case. Consequently, notice under 148 could not have been issued. The question myself is
The statement of objection not filed. Why don't you file it? If you are going to, we are hearing on the main, isn't it? So finally, after it's going to be disposed of, isn't it? So in the meanwhile, you file your objection. Yes.
we also file. We still have the benefit of what they want. Oh, my lord. Further, the next paragraph. Further, during the course of assessment proceeding and such action, it was found that
No, you're reading at? Yes. Yes.
Further, during the course of assessment proceedings and such action, it was found that the assessment artificially inflating the cost of the manufacture of mobile phones. As in purchasing mobile phones from local manufacturers, material for manufacture of these phones is supplied to the manufacturer with entity related to this. I have admitted that there is no quarrel on that. That is why I got a anything done. I was dealing this transaction, the deal international taxation in terms of 92 much before the start. I volunteered in my TV documentation and I submitted myself to the documentation. If I had taken a contention, I'm going for local manufacturer and I don't come under arm's length. I have not gone through the process in the first round. I probably say that they didn't have a case because they had not examined it. In that case, I myself to the documentation. I considered that because the entity from whom I was buying from an entity known to me, consequently the deemed international tax transfer pricing laws, and consequently I submitted it and I showed the lordship the PP, the officer, DRP, the final order. In all cases, all these things have been examined. So I submitted to this tax. So it is not something arranged for the research. Already in the domain of them, much earlier research. As such was only on 21/12/21. Much before that, the order on 34/21 has been passed for ground. For these materials were artificially inflated to keep the profit margin as in a range of 1 to 2%. Based on the evidence collected and submissions made during the course of assessment proceedings for 1819, in their time only on 1819, it was found that the inflation of cost was to the extent of 8 to 10%. During the year, the agency has made purchase of 1,085 crores, 8% the same works out to 86 crores. Required to be disallowed to 37. Logical note is they propose to disallow 86 crores. And on royalty, they propose to disallow 47 crores. Both put together comes to 134 crores. But the earlier officer has already disallowed 150 crores. Which the lordship will again briefly point out to the lordship. The lordship will take it at page 143. What is the last?
Page 140.
143.
Yes.
At page 136, what they are contemplating is 47 plus 86 to 134. Whereas addition made is 150. This is the auditing issues in the paper. You also now to take to 127. 127 is short. Getting that page number 234. Number you also take it.
page 128, also receive addition 1 crore 50 lakh 150 crores. The bottom before penalty. The order. So what they want to say is conceal escaping assessment of 134 crores. The first one they actually added 150.
Yes.
My lord. This is the logical intelligence in the act. Section 149. Provisions have some difference for such statements.
Yes.
And limit for notice. 249, page 1.101. No notice under section 148 shall be issued or the relevant assessment year. If 3 years have elapsed from the end of the relevant assessment year, unless the case falls under B. B may not. If 3 years but not more than 10 years have elapsed from the said from the end of the relevant assessment year, unless the assessing officer has in his possession accounts for other documents or evidence which reveal that the income chargeable to tax represented in the form of asset. The remaining two are introduced much later. Come to the next point. Asset. It has escaped assessment who are likely to amount to 50 lakhs or more. Condition is the assessing officer has in his possession accounts or other documents or evidence which reveal that the income chargeable tax represented in the form of an asset. It will come down below, my lord. How the section was at that point of time? 73 clause B. In 3 years but not more than 10 years have elapsed from the end of the relevant year, unless the assessing officer has accounts for other documents reveal that the income chargeable to tax represented in the form of an asset. It has escaped assessment amounts to or likely to amount to 50 lakhs or more. This was the provision earlier. So you must have in his possession. So account, there is nothing, no whisper at page 130. That is the reason is finding the search is not even recorded. The process of reasoning is not shown. Are they placed any material except saying that it is 2017, 18, 19, we have owed something, so we want to reopen industry backward. This is permissible in law. Each assessment is an independent proceeding. There is no quarrel about that proposition. So, the point I am making, my lord, is after a search, there are no material with officer. Consequently, the officer would not have applied the extended period because he has nothing in his possession. It is not that every case he can open. Extended time limit is as a caveat, as a condition precedent, is restriction by way of this very important conditions. If 3 years but not more than 10 years have elapsed from the end of the relevant assessment year, unless the assessing officer has in his possession account or other documents or evidence reveal that the income chargeable to tax represented in the form of an asset that escape amounts to or likely to amount to 50 lakhs. There is nothing that page 136 as a cost of rectification draw your lordship attention is the core fulcrum of the entire case of the revenue that there is no whisper for the assessment sufficient. Consequently, such does not indicate to them an unbridled, uncharted timeline for them to reopen the assets. Naturally, they are prohibited unless they have some conditions. In my respectful submission, my lord, they do not have any conditions within CBO that extended period.
Ultimately, we are into that. Entry amended section, then I got another, that's a separate point, I did not take up that point on this point basically because there's a more serious point because this amendment can be even be looked into. That's my point number 7, the letter. I will not take to address page 131 and 138 when I address the next issue. I did not want to mix the issue here. The limited purposes such, do they have the information or not? That's all is my limited point. The next thing is the amendment entry is also there in the next. In address those issues. In fact, rely upon a constitution between the Garfield and I'm going to rely upon a other legal intervention. Yes, sir. Time limit has expired. You cannot give limitation. They are relying on 149. They are saying the amount of income escape is more than 50 lakhs. The form of entries in the books of account. They are relying on limit. They are relying upon what the officer says in the note to the Lordship may see at page 137. I cover it briefly now, elaborate later. At page 137, he introduces 149.1 as amended with effect from 1422. Lordship will get that entire clause B is there on the top of the page. Into the Finance Act 22, it's effect from 1422. Admittedly, my search was on 21/12/21 before the amendment. My submission, my lord, the amended clause will not apply. That is independent ground I take. But the officer in this ground number 5, I am assailing that part of the note pertaining to what the revenue was contemplated in page 136 for 2 important paragraphs. I am repeating my argument to make sure that each point has its own relevance. So far, the next point is concerned, I will read the provisions of the other balance of the note. And what they have said that amount of income escaping is more than 50 lakhs. The income charge escaping is represented in the form of entries in the books of account. They are very clearly said it represents in the form of entries. They are not bothered about other items. So, there is 1.3 items are there. I said, I will come to that in minutes. Not want to fix up the issue. So, my lord, my submission as far as point number 5 is concerned, that they relied upon such, no doubt such has happened. No doubt such means some amount of leeway to the revenue to take forward assessment, bring the charge. But the such does not give a leeway because of the specific prohibition in 149(2). After the notice prohibition, that 149 does not talk of such or no such. 48, 148 information, all the talks of such. 149, your lordship may see. Section. If they are making this time limit, there is nothing relevant to such.
There must be material in that nature.
No material. Such 149 amendment to bring in such has been brought in by the Finance Act 23, which has become 1423 regarding such they brought, they are not relevant to us. The time limit for issuing notice 15th March. No way they are diluted because of a search that there is no requirement of the assessing officer to have possession of books of account. That portion has not been diluted by even the subsequent amendment. The lordship will get it at page 1.020 down where they brought in some such provisions in 149. So not there earlier. All our point at this point of time for point number 5 and ground number 5 of this is that does the search indicate anything for you? If it is not indicating anything for you, you have no right to reopen your submission to the lordship consideration. If you have no right to reopen, then they are not, and not they have put any process of reasoning in the only paper they are doing. It's fine, I will address that by not because I have taken some other contention regarding entries that come to that. I may take it to your lordship to point. There is no information released
income chargeable to tax is estimated representing the form of an asset as per the provisions of the Municipality Act. This is the point which I am now going to address the concern with my friend raised. Lordship may take to the main synopsis. Page 37, my lord. Lordship again. There are 6 pages. Lordship will read it. 5 minutes to Lordship. Simply listen to Lordship understand the point where we come from. The line of decisions. Page 37 of my synopsis. There are 6. For me, 6th ground.
Yes.
Submission is my lord. The date of such is the date of such a lordship the notice is 21/12/21. Now, on the date of such, our submission is 149(1)B as existed on the date should be considered. And if on that day, the further information they have amended by way of the amending Act 22, the proceedings have lapsed, they cannot invoke this or the period prior to 21/12. In this regard, now may I again read what my friend wants to read. This is absolutely page 10120. First, this problem cannot be filled. Without prejudice, even if you look into it, there's no bearing because on facts, they do not have anything. On both counts, my lord, the notes made by the officer on page 137 are not relevant, not germane, are not purposeful for the purpose of initiating a reopening of this. Lordship may take 0. What are the protection given to the SSC, my lord, by way of 3 years and 10 years? They said everybody will get open because we want to trust SSCs. 3 years is a general rule. For special reopening of an extended period, they have put some caveats, restrictions, condition precedents. I will read the law as it existed prior first, down below. The law should get substituted to the Finance Act 22. If 3 years but not more than 10 years have elapsed from the end of the relevant assessment, unless the assessing officer has in his possession books of account or other document or evidence which reveals that the income chargeable to tax represented in the form of asset, the state assessment amounts to or likely to amount to 50 lakhs rupees or more. This is what the law at that point of time. Now, that is the only thing that was invoked on the lordship. Page 137, which my friend wants me to address. Lordship will see page 137. They are not invoked that at all. They invoke something which got amended much later. Page 137, last two lines. Hence, 4 lines. Hence, in the present case, notice is proposed to be issued after lapse of 3 years
from the end of the relevant assessment year, and the case satisfied the following condition mentioned in 149. Amount of income escaping assessment is more than 50 lakhs. 2. The income escaping assessment is represented in the form of entries in the books of account. So according to my lord, old law did not contemplate the entries. On the date of such, we need to take all this into. Here you decide to pass a note after 5 years, 8 years, whenever they like. The date that is the date of such, is the date on which they get some extra time limit, extra better, extra power. So that the such they had some reason to believe that I am a person who will not do things correctly. They might visit me in terms of 132. They visited me based upon the warrant they have taken. And they actually take a paper and done. That's never action. Nothing to do with this. So they remove the invoking of this entry itself is stated erroneous. On this ground alone, the entire notice has to fail and fall. No, my lord. Assume this is my first submission as far as this is concerned. In this regard, I seek a lot of indulgence. To read the 149(1)(b) as amended. 3 years, but not more than 10 years have elapsed at the end of the relevant assessment year, unless the assessing officer has in his possession of account for other documents or evidence which reveal that income chargeable to tax represented in the form of asset. They brought in 2. Expenditure in respect of a transaction or relation to an event or occasion. They have not invoked it, nor it applies. It applies more to people spending on marriages, things like that, event or occasion. An entry or entries in the books of account, the escape assessment amounts to or likely to amount to 50 lakh account. Now they are saying that some entry in the book of account, they are more than 50 lakh, represents income or possession of such books or documents, indicate that there is income chargeable tax. That is the meaning. But the very same entries, very same aspect, such does not reveal. I don't want again labor on the change of opinion. All the points will come back into this argument also, because they are aware of all these things. They, right in the beginning, right from 2020, they transfer pricing the matter up to 21 when they passed the final order. The whole case is not allowable and your purchase price is not there. The whole 2 cases that they evolved right from the beginning of the assessment for 17 in the normal court place. In fact, the purpose of transfer pricing is because we filed a transfer pricing report. We submitted ourselves voluntarily to a transaction and did not say that we are purchasing from a local purchaser and we are not getting it. Notice very clearly in there. Please separate. In law, if you have to go through the process, we'll go through the process. Those are bona fides. We are not some fly-by-night operator to run away based on some transaction. We are here to stay, we are here to contribute to the country. So what we did was, we submitted ourselves to interactive tax. They inquired. They are not happy with our explanation. Independent process. But the search does not reveal it. And this something is not in his possession after the search. Because been in their possession right from beginning. They fortifying and buttressing their point by other means for some other year. Yonder nothing turns out on those. We have done this through a particular method. They are finding some support also. As in power, the assessing officer reopened assessment at the 149 when the law very clearly did not contemplate. In regard, my lord, according to us, these 2 contentions, entry in the books of accounts which we have read upon in the notice, not at all relevant for this year. And the lord should take to page number 482 of my compilation. The
27 last paragraphs. Proceeding assessment is not for adjudicate proceedings. But an income tax proceeding is in the nature of a judicial proceeding between the contesting parties. The matter is not capable of even a plausible argument. Income tax authorities who have the power to assess and defer tax are not acting as judges deciding a litigation. That administrative authorities are regulated by statute, but whose function is to estimate the income of the taxpayer, assess the tax on the basis of the estimate. Tax legislation necessitates setting up of machinery to ascertain the taxable income and to assess tax on the income. But that does not impress the proceeding in the character of an action between citizens in the state, commission of so and so. In the period prescribed by the section 34 for assessment is not a period of limitation. Section in turn imposes a pressure upon the power of income tax officer to bring the tax and estate income. It describes different periods in different classes of cases, the enforcement of the right, the state to recover tax, the observe the discourse and so on. So that is all. Over the page, 488. But it may be recalled just before income. It may be recalled. The amending Act of 48, it brings a court of concern.
You're reading it?
On the middle, my lord. One para starting with in considering previous para.
But it may be recalled.
But it may be recalled. The amending Act of 1948, the court of concern. Calcutta Discount Company's case came into court on September 8, 1948. Section 1 describes amendment to Section 34 of the Income Tax Act. These are coming to court on 1 date. The period under the amended section in this new issue, the 34 against us ended on so and so. Before the date amending Act came into operation, and more time had the rights to reassess. Right to reassess become barred. In considering that the amended statute applies section of one of interpretation. To ascertain the for the intent of the legislation to deprive a taxpayer of the plea, action for assessment or reassessment not be commenced on the ground that before the amending act became effective. Therefore, you even in the right to assess or reassess as on account of the expiry of the period of the income tax officer can exercise the power to assess or reassess under the amending act with these extensive legislation was not accepted in the calculated. As we already pointed out, right to commence the proceeding for assessment against assessment as an agent of a non-resident party under the Income Tax Act, before it was amended, ended on 31st March 56. It is true that under the amending act by Section 18 of the Finance Act, authority was conferred upon income tax officer to assess a person as an agent of a borrowing party under 42 in 2 years to the end of the year of assessment. But the authority of the income tax officer under the income act before it was amended by the Finance Act already come to an end. Amending provision will not assist him to commence the proceeding, even though at the date when he issued the notice, it is within the period provided by the amending act. It will be so, notwithstanding the fact that there has been a determinable power, determinable point of time between the expiry of the time covered under the old act, the commencement of the amending act. The legislature has given Section 18 of the Finance Act only a limited resource to operation. That provision must be read subject to the rule. The absence of an express provision or clear implication. The legislature does not intend to attribute the amending provision a greater resource and or authorize the income tax officer for the new act came for the extended period to come part. But essentially, what I am submitting the law of this vision. Considered in the addition of Karnataka could answer on very easier set of facts.
No, so does this mean to say that unlike a substitution, amendment cannot have retrospectivity beyond the protection provided under the old law?
Clearly what I consider is, my lord, I had a protection. What we look into is this. Now, assume for argument's sake, my lord, they will now make an amendment and say apart from entry, they will add other trade things. Suppose the issues which are closed will be reopened, deactivated. Law. And they deactivate everything in law.
Only procedural rights.
This is a substantial right, my lord. You told me I will not do other than assess 50 lakhs. Now you want to take an event. There is no power of the legislature to include that at whatever point of time. Until can that take away my vested right? Vested right of looking only into can it be taken an amendment? The question is also a lot. And this yes, sir. Probably go and give clarity on this. What would happen, my lord, in terms of 201? Not one. Restrictions. We have considered the submission made on both sides. We have the requirements. The 201 APA Act has a clear the Finance Act to no order should be made under one leaving a person to be an SC in report, that over report for that resident in India. Anytime after the expiry, 2 years from the end of the financial statement, the person right? 6 years from the end of the financial statement is made or paid is known in any other case. Two limits. Of course, the provision of amended is section 110/24 by the Finance Act 2000. Issue which arises for consideration of the case is whether the facts of the case, section 201A31 or 2 of the Act apply. Case this second law, limitation prescribed under the Act is not a mere of limitation. The same impose a better on the power of the assessing officer to take action under the said provision. Article law and which I read my law. Similarly, the decision Supreme Court in K. Sharma. In the instant case, admittedly, the statement referred to under so and so has been filed. Finding of fact in the record has been recorded by the Commissioner of Income Tax Appeal as well as tribunal. Limitation of 2 years of prescribed the 201 in the Act, as it existed prior to substituting the Act 2 of 2004, applies to tax case. The limitation to pass an order under 201A of Act expired prior to the Finance Act 2014, which came into force with effect from 1/10/2014. Thus, the right accrued to the city, the subsequent amendment, therefore, would not have received the field of limitation. Taking away the vested right accrued to the city. Therefore, it is evident that the order passed is part of the when the facts of the case, they added 2 more means. You are not there on the day of search. Now, that limit issue notice now they made 10 years. That means, my lord, they can bring another amendment in 2025 and again reopen. You can bring an amendment in 2024 and again reopen. That is why, my lord, on the day of search, ask it permissible to look into it. It is permissible to look into it, they will look into it. On the day, what was contemplated to look into it, only the purpose of asset. And the officer has not invoked that. Page 136, I pointed out to your lordship, he has invoked increase. Increase is not even there. No, my lord. So, 3 year limitation is admittedly gone. There is no quarrel in the truth. From year 16-17, end of March 26, the 3 year 18, 19, 20. Now, your lordship may again take to page 136. Fulcrum of our argument. Assume for argument's sake, do not consider. Argument on limitation, here is on limitation from increase. Potential argument from my friend.
Does the amended provision apply to me? Assume for arguments, not bring up my main argument. How the amended argument reads is, if 3 years but not more than 10 years have elapsed from the end of the relevant assessment year, unless the assessing officer has in his possession books of accounts or other documents or evidence reveal that income chargeable tax is represented in the form of an entry or entry in the books of account which has escaped amount to or likely to amount to 50 lakhs or more. What is the entry they are referring to the books of account? Or the assessment is 16. There's nothing about it to say except the officer saying in the last 2 lines of page 137, by reproducing the section, amount of income escaping admit is more than 50 lakhs, income represented one. He has now clearly enunciated in that limit. There are 3 limits in the section, he is clearly giving the 3rd limit. What is it that he has in his possession? Which is to the process of reasoning in page 136. Nothing in it. There are no entries which indicate that there is income escaping assessment because the 2 issues which are not by entries, by an examination, has already been examined another different provision, and he has come to a conclusion against me. At least I given the conclusion in my favor, a revision and a boost is possible, not a reopening. Here he has come against me, officer has done correctly at that point of time, he will do that. Is that going to be? He will take the normal course of appeal and succeed. The logic will take it to contact. What is the entry that he is referring to? There are no entries about we only talking of under 8 9, and he is talking of my purchases. And the total purchases mentioning amount to an entry, my lord. What is an entry? What is contemplated under the act of entries? In your books of account, you have made some entries. Which have to be enumerated. Just be exhausted written and note. These are the entries I don't consider it as. I consider it. Simply say my entire purchase is wrong. If there is some made for the next year, it should be 8%. Ultimately, my lord, if you lordship for a moment were to look at page number 143. Total operating cost 1,071 crores 84 lakhs. That is second line. Then that is what is my cost I claim. Arm's length price he gave 921 crores. The difference is 150 crores. On my revenue of 934 crores, 150 crores is more than 17%. Why? I have shown much more than 8% what is contemplated. It is added already. So question of he coming to an information that the income chargeable tax is escaped. It's not there at all. Nothing of them represent any entry. Entry must be something which must be patently evident by way of some ledger account or something like that to say this is what the entry is. Merely the officer saying it exceeds 50 lakhs. What exceeds 50 lakhs, my lord? The addition may exceed 50 lakhs, but the reference to form of an entry. Entry in the books of account. Now may I seek a lordship indulgence to the definition of books of account under section 2, subsection 14 at 1.7 of the Act, my lord. No, this one is the beginning 1.7 on it. First beginning of the.
Yes.
Well, yeah. Books of account definition. Books of account include ledgers, daybook, cash book, account book, and other books will kept in the written form or in electronic form or in digital form or printout of data stored in the electronic form or digital form or a floppy disk tape or any other form of electronic package. So the reference to entry An entry or entries in the books of account must be related to this. There is zero correlation in the note which was prepared to any of these items. So saying you purchased some made in home somewhere, so 8% normally there's something. Contemplation under 149(2) of invoking the amended section, there must be a demonstrable, falsifiable data in the note to indicate that some entry is taken to purpose, in which I did the purpose. I have vague suspicion by saying it is somewhere, so this also I am not there. It is absolutely not an entry in the books of. Is figment of imagination of the officer to read books of account. He does not even refer to any of those entries. The way a note has to be prepared by him, he is prepared by him. In all fairness to it, he gave the note to us. Sometimes some officers won't come and we come here and directly to give it to us. The officer is more than fair. If we asked him, he gave it to us. Naturally, we are bound to give reply to this. In the entry now, I have to put a question to myself. Can the final summation of him, the cost of repetition page 136, last paragraph. Royalty is one thing, this is not books of account. Read once again, my lord. My satisfaction and probably fortifying my line of argument. Further, at page 136, second paragraph. Further, in the course of assessment proceedings and such action, it was found that as artificially inflate the cost of material utilized for manufacture of mobile phones. As the purchase mobile phones from local manufacturers. Material for manufacturing is supplied to the manufacturer related to us. In the course of such action, in the song, prices for these materials are artificially inflated to keep the profit margin of the in the range of 1 to 2%. Based on the evidence collected and the submission made during the course of assessment proceedings of 1890, emphasize again, it was found that the inflation of cost was to the extent of 8 to 10%. During the year, the assessee has made purchase of goods. And 8% of the same works out to 86 crores, which requires to serve. What is entry here? He is taking my balance sheet. Not even balance sheet is only a statement terminating from books of account. Nothing to do with my books of accounts. % of the same works out to 86 lakh 80,068 crores 70. Come it is allowed. This very same transaction examined, done against me. So the officer says these are the only thing that is in the note for entry is this para. Earlier para is on royalty. If I have to put a question to myself, my lord, does this satisfy the test of entries contemplated under 149 1B? My respectful submission to the lordship consideration is it fails, and in fact, the note does not indicate any whisper of any entry, the basis for them to decide whether it is more or not. At most, we have taken it from the financial statement and not on the entries. These financial statements are no doubt moved to the books from the books of account. We do whatever necessary. The auditor is expected to point out the entry is wrong, not the financial statement. Financial statement where the problem of the balance sheet falls. That cannot be the basis to invoke 149 1B extended period. Lastly, my lord, on this point, most important. None, the assessing officer does not have any information in his possession or evidence which reveals that income charges are within the form of us. What is in his possession? Same thing it was there. That is the reason he is not able to write a detailed note, my lord. Maybe for the year ended 18, 19 years, not some email years, the not the same. We'll address those issues when we come to those years. As far as this year is concerned, nothing to say that it is. We want to go to club tomorrow morning.
No, live law will report that I'm hearing till 9:57. We can take a screenshot and share it. Except for that.
Two more points.
We'll continue on next witness day.
And 45, 2 more points are there. Inspection will be extended.
Same one. Same one.
Our submission.
My lords, one submission.
Serial number,
Just wait, madam.
serial number 4, my lord, I've been waiting for. But somehow I'm not able to.
50? You are in the queue. You have to wait.
Been waiting for a very long submission of documents.
13. The list is full. 13th, we'll try and take it up. The list is full. We'll try on 13th. Let us see. Yes.
My lord, serial number 53.
6. All final hearing 6. Final hearing matters. Until these part right matters finish, final hearing, I don't know if it will reach also. How can it happen? Fifth, is it? So it requires hearing or what? What is it? Let us see, we'll repeat it. Hearing 11, 13, 19.
My lords, one submission.
Yes.
Serial number 53, appearing for petitioner.
Yes.
Kindly list the matter for next week, 28th June.
13.
My lords, may I make a mention, my lords?
Yes.
Item 56, my lords, only a limited provision release of the car, my lords, which was seized 1 year back. There is covered judgment also where my lordship predecessor in identical matter has passed orders, my lord, for release with some conditions. Only on a limited prayer, my lord, this is pending for more than 1 year, my lords.
Interim prayer is not considered, is it?
No, my lords. Only release of car, my lords.
List the matter in the orders list.
My lord, serial number 58.
Yes.
My lord, it could be posted on 6th July, my lord.
58. Oh. 13th, we'll have it on 13th.
Obligement. Interim orders to be extended, my lord. It will expire today.
Only want is extended to the next.
Obligement.
If there are some covered matters, suppose in that you say like what we disposed of on 148, something like that. If according to you it's covered, Then we'll have it in the orders list. You can make a mention. What we can do, no, sorry, what we can do, we'll have it on Fridays. On Fridays, we are having other matters. Anjana, I'll tax, 3-4 kaliye on Friday. So Fridays, Fridays, we'll have, you just make some listing. Every Friday, you give some 5. On Fridays, we'll take up old matters. So that you make a list and you give it to the court officer. We'll try to put a few matters at least we'll distribute and put it on other than tax. 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 Hale matters no decided so far. In this, you file your objections.
Purely legal issues. Gets indoor place.
No, but in case they want to advert to it, so during the course of
only purely legal issues are.